time on the live stream, well, on the recording, but that's just life.
Oh,
It's not what we
I
usually
can
like
bring Willow in here and have her sit up here and
entertain us.
entertain.
Yeah, there we go. I used to work for radio, so it's like dead time. Like
Oh,
you don't want that. You don't want dead air. All right, let's see. I'm gonna let people in now.
you can be loud all you want right now. I have a new screensaver.
Ooh.
Should have done that before everybody came on.
That's all right. Hey, proud grandma.
She didn't come yesterday.
Oh, that's right. Oh, is yesterday was her day? I thought Mondays.
Mondays and Wednesdays,
Oh,
but
and
Wednesdays,
that's variable.
Wednesdays, if I have to work, I work, which is like all the time.
Yeah, no, with me around, it will be.
Well, Bill's home in time, so it works out. But yesterday they were both off school, so they just stayed home.
So let me just make an inquiry here. So I do see someone joined us with the screen name J Cop, and I don't see you listed on our evidence list. I was just curious what your connections.
Yes, I'm Jennifer Kapp. I'm with Kenosha County. I'm the attorney for Kenosha County.
Really? Huh.
Yeah,
Let me. Okay. Oh, you're not on our evidence list because you're not a witness, so that's good.
right. Yes.
Okay, so on the service
Mhm.
list. Okay, great.
Yeah.
Thanks. Sorry
Mhm.
about that.
No worries. All right, I joined early just in case there's technical difficulties and I need to call our help desk for some
I
reason. So,
appreciate that 100%. Yeah, we'll see people joining like after 10 and
yes.
it just
Yes.
makes everyone else wait longer.
Mhm.
Uh, so I'm sorry, was it Jennifer? Was your first?
Yes, Jennifer Kapp, KOPP. I'm the attorney for Kenosha County.
Oh, yeah, still waiting for a bunch of people. So we have our live stream running in case people want to check and make sure that's working. It's already up and running. So we're just waiting for people to join us, and we still have many people to go. So we'll hopefully get started at 10, and we'll take it from there. So unless there's anything else someone needs to address at this time, I'll just say sit tight and wait. But go ahead if anyone had any questions. No? Okay, thanks. share up with our notice of hearing. In case you're wondering if you're in the right place. You're doing a pretty good a pretty good job connecting names with parties. But Renee has got me stumped. If you could just indicate if you are connected, which party you're connected to, or commission staff. I may not know you from commission staff. Does anyone recognize Renee being connected with somebody else? Give Renee a few more minutes here to let us know. Oh, sorry. I was trying to notice. Okay. Renee, a few more minutes to let us know who that person is.
Hi, Judge. This is Matt Frank. Can you hear me?
Yes. Yes.
Okay, good. I was testing my speaker, and the speaker told me I could hear, but I wasn't sure if you could hear. So thank you.
Okay. Yeah. That's fine. A few more minutes to go. I think we have missing any parties yet. They have one person.
I know Sophia Rogers is about to log in.
No, that's fine. Just checking if somebody from everyone we're expecting. Well, it looks like Renee dropped out. All right. Looks like we have all the parties. Looks like we have all the attorneys we're expecting joining us. Well, maybe not. Yeah, we have everyone we're expecting. We'll start with the procedural matters. So if there's a few witnesses that still need to join us, I'm gonna leave them in the waiting room until we're done, or at least until there's a good break to let them in. All right. So it looks like we have our notice on the screen there. So let's get on the record. This is 6630 CE 316, the application of Wisconsin Electric Power Company for a CPCN regarding what we're calling the Paris RICE, RICE project. My name is Michael Newmark, the Administrative Law Judge for the PSC. We're here on Zoom for the party hearing session to collect the evidence from parties and commission staff and subject witnesses to cross-examination. We've already had our public session on Wednesday, February 5th. We collected public comments, and we're still continuing to collect written public comments up until Monday, February 17th through the commission's website or by US mail. And the details on how to do that are on the notice of hearing displayed on the screen share. They'll be part of our YouTube recording. and also, yeah, available on the commission's website. So just feel free to check that. So moving on to more relevant matters here, we're going to have appearances on the record. So we'll just start with our service list in alpha order. Just wanted to know, I'll let people note, you're probably all aware of this. This is a list we use to serve documents, the list that the commission uses to contact parties, including what it'll use to issue the final decision in the case. So be sure to note any errors or omissions on this list. I know we do have 2 new entries for the applicant that I just received notice of appearance for, but let's start off verifying the list here and who's making an appearance with Citizens Utility Board.
Good morning, Corey Singletary for the Citizens Utility Board.
Okay.
Steve, I'm also here. Steve Keim, Citizens Utility Board.
I'm gonna make my go off the record for a second. I'm gonna make my view here a little bigger. Grab everybody on the screen if I can. Adjusting that as we go. Okay. So let's continue on. It's Cub. How about City of Milwaukee?
Excuse me, Judge.
Oh, on the record, yes.
No, I need to restart. My
Oh.
computer just blipped out. It'll just take a second.
Sure. Well, in the meantime, I'll let in one person here. Let in.
Go ahead. Thank you.
All right, great. So back on the record. Who do we have for City of Milwaukee?
Good morning. This is Assistant City Attorney Tom Miller for the City of Milwaukee.
Thank you. Clean, Wisconsin.
Good morning, Your Honor. Brett Cordy for Clean, Wisconsin.
Kenosha County.
Attorney Jennifer Kopp, with the Corporation Counsel's Office on behalf of Kenosha County.
Great, thanks. Public Service Commission.
Sophia Rogers, and also with me is my colleague Stephanie Bedford.
Renew Wisconsin.
Your Honor, this is Andrew Kell with Renew Wisconsin.
Okay, Town of Paris.
Your Honor, John Holloway, Town Chair, Town of Paris.
And Your Honor, this is Jared Walker Smith and Richard Heineman, attorneys for the Town of Paris.
Thanks. Wisconsin Electric Power Company.
Good morning, Your Honor. Attorney Proctor Brown, and present with me are attorneys Phillips, Wilson, Goldschmidt, Gutner, Fortune, and Rakosi. I think I have everybody there.
All right, and just a note for the court reporter, I'll get you those new names for you, or you probably have them in your system anyway. All right, and Weeg, sorry.
That's all right. Good morning, Steve Heinzen for Weeg.
All right, and Wisconsin Local Government Climate Coalition.
Good morning, Your Honor. Matt Frank from the firm of Murphy Desmond, appearing for the Wisconsin Local Government Climate Coalition. And I would just add on the service list, there's an M missing before Frank in the email address.
Oh, really? Okay. Sorry about that.
That's all right. I've been getting all the communications, but I just thought I'd mention that.
Oh, okay. So maybe the list is okay. That's fine. It's probably just what you're seeing there is wrong, but the email probably just put itself in correctly. Thankfully for that AI stuff that's going around. All right. So I'll double check that, make sure it's working. All right. Great. That's our service list. And that's all we need to do there. Appreciate that. All right, so before we go off the record, we can do most of this off the record, I think, but I wanted to note before we do that I think we're gonna talk first about whether we can excuse some witnesses. It looks like there are a few that there's no cross expected, and we want to discuss the order of witnesses. There's a few maybe that we need to take, or at least acknowledge that there may be a specific time to take them. Then we'll go back on the record for some other things, but let's do this first in case people can know their order before it gets too far down the road here. So we do this off the record. So in the offered evidence list, so I did acknowledge that or communicate that there's potential for going into Friday in this hearing. And parties did a good job explaining what that might do with their witness availability. So it looked like there were a few that I think if we do need to go into tomorrow, we would take them in the morning. So just want to note for everyone here that we'd probably need to take Burgess either in the morning or after. They're not available between 12 and 1. Singletary not available between 1:30 and 2. So maybe in the morning, maybe in the afternoon. Jester, need to do Jester in either morning. So I'm expecting probably tomorrow morning. Sherwood again, morning or afternoon. So that's kind of the state of affairs with that. But in terms of parties, the witnesses that we can excuse and just have them verify their filings by affidavit. Looked like there were a few that there are no questions for, and if that's still the case, we can go ahead and excuse them. But let me ask about that first. So I'm assuming with the applicant, I guess I don't know this yet, but if there are no objections to the rebuttal of, for example, we can accept those documents by affidavit. But if we need to do some more discussion, we need the witness, then we won't excuse them. So I guess just open conversation here. Do we know what we're doing with someone who's excusable or not? So okay, I'll just say any objections to the rebuttal? No? Okay. So is there any cross at this point for Arndt? No? Okay. No. Green light them. Light. Lambert, how about Lambert? Was there any objections to sir, or cross for this witness?
Your Honor, this is Matt Frank for the Wisconsin Local Government Climate Coalition. I believe Lambert, there was just filed yesterday there was a new exhibit relating to MISO. In terms of Sir rebuttal to Allison Carlson's Sir rebuttal, it didn't seem as though, I mean, it wasn't responsive to the Sir rebuttal. Our witness in her Sir rebuttal did not discuss MISO and was not a topic either in the rebuttal that our witness was referring to. So I do have, I guess I would object to at least hear what the basis is for introducing MISO evidence at this late stage.
Okay, well, let's leave that person off.
So actually, do you mind if we address that? Because I think there's a bit of a misunderstanding, Your Honor.
Well, okay, so I just wanted to go through the list quickly to see if we can excuse people that we can, and then we can get into more detail. So how about Nicholas? Was there any, I guess there's really no objections to rebuttal, but any cross for Nicholas? No? Okay. Cyber or Sieber? Any questions? Zasner word. I'm pronouncing that close. Questions or cross or objection? Oh, yeah, no objections already. That's already done. But so cross for that person, no. All right, Zamudo, there's sir, but so any objections or questions? No? Okay, look like Cubs witnesses, everyone's getting questions. Clean. Hotling or Hotling. Any?
Your Honor, we have some sir on the stand
Sure.
for witness humbling.
Okay, Hodling, is that right? Saying that right? Okay, so I'll just. Sherwood. Any cross or, yeah, I guess you supplemental direct as well.
None planned, Your Honor. I would prefer to verify on the stand unless witness Sherwood can tell me here that she has access to a notary.
I have access to a notary.
You do?
I do.
Would you rather be excused and take care of it that way?
That's fine with me if that's good with you guys, with my client.
That's fine.
Okay. Kel. Didn't look like they were cross.
Your Honor, I would just say, even if there's no cross, I would like to verbally affirm since I have to be here anyways.
All right. Befield from DadCap. Any questions? No. Golden. Didn't see any questions for Golden. Now, usually staff takes the stand just to verify documents, but I'll leave it up to them for that. So let's leave it. I'll just leave it blank. Well, I'll just indicate no questions. How about that? That's information we can use. Rademacher, any questions for Rademacher? Rowe. Schumacher. Tomasechki. God, I'm gonna get in trouble. No questions. All right. So it's up to, what I can say is they're excused for purposes of making an appearance, everyone in blue here. But it's up to the party whether they want to call that person to verify or to add testimony as their last statement that's allowed in the facilitating matters order. So just to be clear, there's the potential they don't have to be here. So let's get on the record. So we've discussed the possibility of cross and whether some witnesses can be excused pending verification by affidavit. And we do have a list of people here. So it's Arndt, Nicholas, Sieber, Zasner Word, Zamudo, Sherwood, like I said, can still take the stand, but no, we're not expecting cross. I guess Cal is the same way. We're not expecting cross. They can still take the stand. And then commission staff witnesses, looks like everyone but Minke is in a similar situation. They may take the stand to verify and add to their testimony, but there should be no cross. Okay, so okay, so it didn't look like there were any objections to Sur rebuttal and the related exhibits except for Lambert. Is that my understanding correct? Anyone just chime in if I don't have that correct. I think I tried to reflect those filings in at least this version of the offered evidence list, so I can keep track. I can't remember if this is the one I sent to you. But I did note on the Lambert 8 is the new exhibit that came in on Sur rebuttal. I didn't see that in an email, and I may just have missed it. So I don't know. It sounds like other people got it. Was there any? I guess first of all, I'm going to need a copy. So let's go off the record just to make sure I can find my copy.
Your Honor, if it helps, it was emailed by Colleen Sipiorsky yesterday at 10:08 a.m.
Okay.
Just verifying that you were on distribution.
Yeah, I got all the other ones, so at least that.
Yeah, it looks to us like you were on it.
Not showing up.
Should we bump it in your mailbox, Your Honor?
Well, I'm just not able to opening my mailbox for some reason. So either way, there we go. Either way. Okay, let's see.
Yeah, it was emailed as a standalone document, not with the rest of the testimony.
I see that. Yes. Okay. Great, thanks. Okay, so just so I know I'm in the right place. That's the Lambert exhibit. So it's energy efficiency.
That's the correct. That's the correct document, Your Honor. And I guess I would just note in response to Attorney Frank.
That was off the record. So let's get on the record and see if we can collect that information for everyone here. So was it Attorney Frank that was questioning I guess relevance? Well, I'll let you speak for yourself. Any objections to the Lambert Sur rebuttal, including the Lambert 8?
Your Honor, I think and I may be mistaken here, I thought WEPCO had filed several documents just yesterday referencing MISO and demand response reviews.
Could that be for cross-examination? Is that rather
yes,
than?
Your Honor.
Okay.
Yes, Your Honor, that's correct. The Lambert 8 is not a MISO document, obviously. It's the company's most recent customer service conservation report.
Okay.
Yeah, we don't have an objection to the We Energy's 2023 annual report.
Okay. Yeah, I think so. There's another list of documents you've seen. I have them collected in a folder here. So these documents are the ones that I noticed were for that parties were going to use for cross-examination. So that's another part of this Zoom process to provide those documents electronically before the hearing. So it could be in one of those documents you noticed a MISO document. Is that?
Yes, Your Honor, there are a couple of MISO documents among those.
So I guess we'll wait and see. I mean, those are used for the intent. I'm assuming is that they'll be used for cross, and I guess it may not be tied to a particular. At this point, I don't see a particular witness this is tied to. So as far as the Lambert testimony goes, It looks like there's some confusion about that. So is there any objections to Lambert's sir? At this point? No? Okay. And in terms of Lambert appearing, we were kind of withholding that before in order to deal with this potential objection. So is there any need for Lambert? Any questions, cross questions for Lambert? No? Okay, so I'm going to add Lambert to the list of people we can excuse with an affidavit. Okay, so I think at this point we have noticed all the documents that have been filed so far. I don't know if I'm missing anything on the offered evidence list. Oh, there was one question I had. We'll probably do this off the record. So I did not seem to be able to find the Sir, the Stasic, the public version. And that maybe I missed it, but I ended up inadvertently, unfortunately, including the confidential version in the offered evidence list that I sent out. And that was not password protected as it should be when provided by email. So that's water under the bridge, unfortunately, but I just didn't know if there was a public version, or did I just miss it? So,
Yeah, Your Honor, it was served by Colleen Sipiorski yesterday at 9:47 a.m. with the rest of the company's source or rebuttal.
okay, probably just missed it. All right,
There
so in
was
case we need to
separate-
reference that, I'll deal with it.
Yep, there were separate emails for the confidential and public.
Okay.
And apologies for the password.
Okay, so
Judge, there's one more. If you don't mind scrolling down, I'm not sure if we have a placeholder for the data request response exhibit.
there is now.
Okay,
Yeah,
thank you. And it's delayed. We had some really late data requests, and we appreciate the applicant's responsiveness and are still I don't believe we've completed that exhibit, but it'll have just the usual no surprises, just the responses to memorialize everything in one spot.
Yeah, the requests and then the responses.
Yeah.
Yeah, just so, I mean, if I know staff's extremely busy, but these documents, the intent in the facilitating matters order is that these documents be filed so that parties can refer to them, and then it gets updated as new stuff comes in. So
Okay, so you would rather have a revised come through? We just had an uncharacteristically set of questions in this particular proceeding, but we can take note and aim to provide data request responses in advance of hearings and then revise them as needed.
yes, please.
Okay, sorry about that.
That's right. It's in the FMO instructions on how to do that.
Okay.
Then I think we're missing the final environmental impact statement, the actual exhibit. So we'll need to.
Thought that was posted. We'll get that posted.
Okay, maybe I missed it.
And if I could, this is Corey Singletary from Cub. I just wanted to confirm either with Attorney Rogers or Your Honor. So that would include, that final update would be including, I believe, all the responses, or at least in part, the responses to PSC Watson KG Series 8. Okay.
Yes.
Okay, so those will be included in that exhibit and so part of the record. Absolutely,
yes.
Okay, thank you.
All right, good. So that leads me to the next question. Any errors or omissions on the list? Can start with the applicant. And I know I'm missing Lambert 8 because I didn't see it before. I'll get that in there.
I don't believe so, Your Honor. Don't believe so at this point.
Okay. And any other interveners, any errors or omissions?
None at this time from Cub.
I'll just ask clean since I have so many filings. Did I miss something?
No, Your Honor, it looked good.
All right. Okay.
Your Honor,
Yeah.
this is Matt Frank,
Yeah.
Wisconsin Local Government Climate Coalition. Just a follow-up question. I've actually prepared our amendments based on your direction earlier, and we're holding off filing until after the hearing. So in testimony, when a witness is referring to a previous PSC docket, I'm assuming we can refer to the docket number just in general terms without inserting the not record evidence. But if you refer to a matter in the docket, then you should put in the NRE disclaimer. Do I have that correct?
I think generally you're on the right track. I mean, it's sort of a squishy standard, and I get that. It's you know, it does take a little bit of subjectivity to decide whether you want to put the NRE. I mean, it can't hurt to do that, but although I guess some parties have just slapped that disclaimer in when there really are no citations. So kind of I guess it's a good backstop, but you know, I guess it just lends yourself to wonder. But then so yeah, so if you're just describing that a docket exists, I suppose the docket number is fine. I think where it gets a little tricky is if you say the commission told us to, or the commission said, then you really should be citing to the order. So I noticed that happens a few times. And it could be what I'm talking about right here, this 29. And I don't know, do you need me to get into that further, or does that give more of a direction?
No, that's helpful, Your Honor.
Okay.
I think, as I said, we've already kind of prepared our amendment. We didn't file it. I just wanted to, that's helpful to know. Thank you.
Okay. And you just anticipated my next question, which are questions about the comments I have here. Any filing related questions that I've, in terms of the comments that I left on the offered evidence list?
Your Honor, this is Jared Walker Smith for the town of Paris.
Yeah.
I had a comment about whether there is a cover page to exhibit TOP Holloway 11. And there is not, but we are prepared to provide a little more foundation when we bring John Holloway up for direct.
Okay, appreciate that.
Okay, thank you.
Your Honor, Corey Singletary from Cub. It's just a clarification. I think I know what I need to go back down to that spot here. The comment on witness Burgess's sir rebuttal. You put in that you propose to change the existing reference at sir 6:1-3, that you change the reference to, it says at least in the version I have, EX Cub Burgess 22, but given what follows, I'm assuming you meant your proposed 32, which is the document you attached to this list.
You're correct. Yes.
Okay. All right. Perfect.
All right. Any other filing related correction questions?
Your Honor, for hoteling, Exhibit 16, you noted the title page. That data was downloaded from the MISO Interconnection Queue website. Would just including the URL as in that, or a screenshot of the web page? What would you prefer us to do there?
Yeah, it just kind of looks very odd. I guess, well, a screenshot would probably be good. Yeah, if there's some sort of like data entry page, if that's what you're thinking of. I don't know where this is coming from. So
yeah, we can include a screenshot of the page where the data is available to download.
Okay,
thank you.
That sounds good. Anyone else?
Your Honor, we had a few comments or questions on a few of your entries, and maybe it gets into some of the other issues we want to cover around confidentiality.
Probably does, yeah. Okay, go ahead. So should we get on, well, let's deal with, if it's more of the confidentiality, we'll want to be on the record for that, but otherwise, if it's just filing matters, we can take that off the record.
Sure.
I didn't see any questions.
So while you're thinking, I just wanted to point out, we can do this off the record, just these new exhibits that I was adding in, and just want to make sure everyone's clear. And it does, I guess it involves WEPCO probably the most, just in terms of refiling some documents because of the format. And I tried to put a little explanation in the offered evidence list in the back to give you some, did a little investigating and tried to find a way to create these documents so they're a little more clear and there's no over typing. Hopefully that's going to work. I mean, you can just use the documents I'm providing, but if you know of any others that I missed, you can certainly feel free to attempt to create a new version. Otherwise, just be mindful of that in the next round of cases. And you know, I think a lot of websites used to provide that printing function, and that usually worked really well. And I've seen that disappearing now, so it makes it a little more difficult. But Adobe actually does provide a number of options there to make a better printout of the web page. I don't know if some freeware versions of that PDF program has the same functions, but hopefully everyone here has Adobe.
Yeah, Your Honor, I think sometimes when we create these documents, we're caught a little bit by not wanting to misrepresent the document and, you know, erase things from the top of the page. But
right,
if it's non-material, I guess we'll do our best to find a printable version. Can't do that, we'll just delete enough stuff from the top of the page to make room.
Yeah, I think what we want to make sure is that the text that you want to convey is clear. And the problem is usually there's ads and other things that can just kind of pop in the middle, and you're like, wait, no, I didn't want to sign up for that. I want to read the article. Yeah. Okay. And then just while we're on the page here, so there was this one note that I had for Burgess's surrebuttal, which was a dynamic table. So it looked like when you click the link, it wasn't actually showing us that table. And it's a good idea to use a screenshot like you did in testimony there, but maybe just putting a note of that in the testimony is helpful.
Your Honor, would you like us to file a revise that it has that notation that it was a screenshot taken from that dynamic?
Yeah, I think, are you already refiling that?
I might be. Sorry, there's a lot of documents in this.
Yeah, I think I mean, if I'm already asking you to refile, well, why don't we go ahead and do that just so it doesn't confuse anybody?
Okay. And then on the refiled documents, on a comment attached to EXCUB Singletary 1, it looked like you had direction for WEPCO to provide a revised version of a document.
Yes. Yeah,
Okay.
I didn't know if there didn't seem to be any questions about that, but I just want the executed version of that file.
All right.
That didn't seem to be, yeah.
We're prepared to do that. We'll supplement the response and get that to you, Corey.
Perfect. Thanks.
Great.
Sorry,
so
Mark, on the offered evidence list for direct WEPCO, Hagerty, Arietta, you had a question about why some of it is being deleted.
Oh, right. Yeah, why don't we take that on the record then? So let's get on the record and just want to introduce that for us.
Sure. Your Honor, for direct WEPCO, Hagerty, Arietta, you had a question about why a sentence was being deleted. The answer is that it was repetitive of that same sentence earlier on the page. It was a typographical error, essentially, to include it twice.
Oh, okay.
It must have been moved in
the same.
moved in the editing process and didn't get deleted.
I guess you just start reading these things and they just all the same. All right, great. So I appreciate that. There were no objections to it. It seemed like a big chunk of text to be deleting. So okay.
Understood.
And
then sorry. On exhibit WEPCO STASIC 11, you noted that it was a duplicate of STASIC 9. We'll get the correct thing filed there, which is prior testimony from Microsoft.
Okay.
And then other than that, I think the questions had to do with confidentiality.
Yeah. Okay. Well, I think I can probably just address that quickly. So yeah, so in the the confidentiality request process has the forms that you see online, and it's that sticky item 5 that asks to explain why the document to explain why the information being requested for confidential status meets the standard that's being claimed in item 4. But what I've seen in, going back many cases is that and for many filers in general, there's kind of a cursory explanation. And I think it gets a little tricky for us to be able to, for us to be able to rely on that in the case when we need to, if we ever get an open records request on these documents, we want to be able to have a full explanation as to why we are maintaining confidentiality or why we are removing that redaction from the public and from public inspection. So to have more information is always best. I've been trying to communicate this in many cases in the recent past. I believe we went through this in the WEPCO rate case, but I might be mistaken. But I think what's important is that WEPCO did make a filing that goes and further explains that. Was it this morning? Saw that filing, and
Yes.
Yeah, and that's fine. That just what I was looking for is just having some more explanation on the record about that, or on file. I guess it doesn't have to be on the record. But I did want to mention I wasn't trying to surprise anyone about this, so I did include that direction in my January 2nd email to the service list. Includes a variation of the first round of our offered evidence list. And for Gerlikowski, which at the time was the document that had confidentiality claim, I did ask that the witness provide more detailed explanation on the record. So it would have been done here today as to how the data claimed to be confidential meets the criteria the applicant chose. So, and I did that for other specific filings. I just raised that question in order to have WEPCO complete that explanation here today, but I think we have that on file right now, so it's fine.
Your Honor, do you need us to do anything further on that? Are affidavits necessary, or what you have now suffice?
Well, technically it would be according to the FMO and according to PSC 2.12, that filing should be done with an affidavit. I guess I'm not gonna require that. I guess the applicant can figure that out. I'm not gonna make you do any more than you've done at this point here today. So I did want to mention though, the document that we did receive was filed publicly and does name a customer. I mean, that has the customer's letter that backs up the applicant's claim. And I guess just in terms of efficacy on the record, how we deal with things going forward today, the name of this company, are we still treating that confidentially for purposes of the record, or has it been said enough times in public that it's no longer necessary to keep confidential? I guess that's generally the question I
Our
have.
preference, Your Honor, would be to handle issues related to that customer, particularly with respect to its load and contractual arrangements with the customer in closed session, if possible, to maintain confidentiality. Understand that there has been reporting both in the media and disclosure of the identity in this case, but erring on the side of caution and recognizing the importance that the customer places on keeping this information confidential, maybe our preference to handle it in closed session if possible.
Okay. Yeah, I have no problem with remaining enclosed. I guess it's confusing to me that that document was filed publicly, and I don't know. I guess I appreciate things being filed publicly when they can be. I just hope that doesn't make things more complicated for everyone.
Yeah, Your Honor, we had permission to disclose the letter.
Okay. So, and I'm trying to find this now. So just bear with me. Just go off the record for a second. So I just wanted to be, I was just curious because the letter does indicate, and it acknowledges a non-disclosure agreement by which the utility, the applicant, is relying upon to make its claim for confidentiality. So I would be curious as to whether the applicant could file that in this docket as confidential document, so that we have that as well to back up the claim of confidentiality for the documents that have been identified.
We can do that, Your Honor.
Okay, great. Appreciate that. All right, so that's, I mean, is there anything else we need to discuss on the confidentiality issue? No, and I guess there are some notes that I.
Are you back on the record?
Oh, we weren't on the record.
You had said you went off the record.
Okay. All right. So, okay. Let's just use the YouTube recording. No, do not use the YouTube recording. So on the record, we did discuss an item related to the confidentiality requests for the applicant, and in terms of the notes that I made on the offered evidence list, I'm comfortable with what the utility has filed here today on earth, acknowledging and providing additional information for those claims. And my intention was just to make sure we had adequate information in order to maintain documents under our rules. The applicant also acknowledged that they will be filing the non-disclosure agreement that was referenced in that letter, and it can be done as a confidential document. So I did want to mention there were some references in the offered evidence list that asked interveners to also justify redactions in their testimony. I think we're going to let those go because they are related or derived from the applicant's information. So any questions about that? Okay, so I think we're good to go. Anything else we need to address?
Your Honor, just one item related to the last page of the offered evidence list and two issues that you directed us to address in briefs.
Okay, yeah, that's true. So yeah, this is it's unartfully termed as parties shall address in their briefs. Really, this was more of a heads up. I think these are interesting issues, and commission would benefit knowing the parties' opinion, legal opinion on this. I think there has been some. Well, I think the term that's been used is there's an obligation to serve. I don't know if people have actually cited 196.03 sub 1 that I could find in testimony, but the idea that there's an obligation to serve a firm load to a particular customer in question, for me, raises a kind of a novel issue, I believe, when looking at the tariffs and the other, basically the tariffs that WEPCO has, and how it relates to service under the statute and other items that are being discussed here. So take that as a encouragement to address that. I've had, although I don't talk to commissioners about these cases, they do they have come to me in times where they said, "Oh, I like that brief question you asked them." So it may be useful. I have no knowledge that they want to know this, but it may be useful that after the fact they would appreciate hearing about it. So just putting it out there for you.
Appreciate the context, Your Honor. In our view, the questions being posed here aren't directly relevant to the statutory grounds for CPCN approval. And obviously they weren't included in the issues in this case. And our principal concern is that there are 30-page and 15-page limits for briefs. Those are already difficult for applicants because we have to address arguments from
So let me
many
just interrupt.
parties.
I'm sorry. So I'm not requiring you to do it. So let's move on. Okay. All right. So I think we can start with witnesses. How does that sound? Anything else?
Your Honor, I'm sorry. I do have one more question. It dealt with confidentiality, but not specifically with the customer. You marked a part of Jester's direct testimony as questioning the confidentiality. I spoke with the case coordinator and explained that the figures we use were derivative of confidential figures, so we felt it was better to err on the side of caution and use the calculated figure to redact that. Is that okay to leave it that way?
And yeah, what was it, Jester you mentioned?
Yeah, Jester direct.
Okay. All right. Yeah, if it's derived, then I would just leave it alone. Yeah, I guess I wasn't sure where that was coming from. That's probably why.
Thank you.
That's fine. Yeah, sure. Anything else? Okay. Let's take our first witness. Let's have begin with the applicant.
Applicant calls Michael Haggerty.
Okay, so you guys gonna use, let's go off the record. You're gonna need to switch people. Okay.
Yeah, we'll switch the attorneys one, I guess, to be the witness.
Okay. So let me just that. Trying to keep up with this. And I believe if I spotlight you, you're going to show up better. Does that work for everybody? All right, I think we're good to go. Oh, let me silence my phone. All right, let me swear you in. Raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
All right, go ahead.
Please state and spell your name.
John Michael Haggerty, JOHN MICHAELHAGERTY.
Did you prepare and cause to be filed direct rebuttal and certiorari rebuttal in this case?
I did.
Did you also prepare and cause to be filed accompanying exhibits?
I did.
Do you have any corrections to your testimony?
I have one.
Which piece of testimony?
In my certiorari rebuttal, I believe it is, on page 3.
What is the correction?
See it on line 4. And line 3 and 4 says such startup costs are accounted for in short-term modeling in Plexos, but not.
Sorry, sir. Can you just read a little bit slower because it's hard to understand you?
Sure. I'll try to speak up as well. Such startup costs are accounted for in short-term modeling in Plexos, but not in the long-term modeling. And the correction is, it should say, instead of but not in the long-term modeling, it should say and in the long-term modeling. That is all.
Subject to that correction, if I asked you the questions contained in your testimony today, would your answers be the same?
Yes.
Mr. Hagerty is available for cross.
All right. Before we move on, I did want to mention that there were no objections to any filings that are on the offered evidence list, so they'll be received pending verification from the witness. And that's it, I think. All right, let's have any questions for witness Hagerty.
Your Honor, Clean Wisconsin has some questions for the witness.
All right, go ahead.
Good morning, Mr. Hagerty. On pages 20 to 23 of your rebuttal testimony, you discuss interveners' arguments that WEPCO should increase demand response. Specifically on page 20, you say that, quote, demand response cannot be accurately included to a greater extent in capacity expansion analysis like those relied upon by Wisconsin Electric and Clean Wisconsin in this docket, end quote. Do you know what percentage of WEPCO's peak system demand Clean Wisconsin witness Hodeling modeled as demand response resources?
I do not.
Thank you. And Mr. Hagerty, you're a principal for the Brattle Group, correct?
Yes.
Your Honor, I'd like to turn to a document I provided to the parties yesterday titled The National Potential for Lead Flexibility, Value and Market Potential through 2023.
Okay, got that here. Do you have a copy over at WEPCO's location?
We'll pull it
You
up,
can
Your
use
Honor.
the screen share if you can see it, but
Yep.
I can see it.
Thank you. Mr. Hagerty, are you familiar with this document?
I am.
And this document was prepared by your firm, the Brattle Group, correct?
By colleagues at my firm, yes.
So I'd like to go to page 5, that's page 6 on the PDF of this document. Mr. Hagerty, this graphic shows that your firm identified demand response capability in Wisconsin as greater than 10% of system peak. Is that correct?
Sorry, I was reading the document. Can you repeat the question?
Yeah. So this graphic shows that your firm identified demand response capability in Wisconsin as greater than 10% of peak system demand. Is that correct?
It is. I'll note in the footnote at the bottom of the slide, it says that the states have been proportioned relative to their share of ISO peak demands. So I do not believe that that is based on a state-specific analysis, but a regional analysis that has then been allocated based on the approach that is noted here to Wisconsin. So I would not interpret that as a state-specific analysis of the capability specifically in Wisconsin.
Okay, thank you. Your Honor, I'd like to offer this document as Exhibit WEPCO Hagerty 20, I believe.
any objections? Okay, we'll mark it Hagerty 20 and we'll receive it in 3 business days. Please file it by then.
And sorry, Your Honor, do we file that or does the applicant?
Yes, you go ahead and file it. That would be
Thank you.
the appropriate way.
All right, Mr. Hagerty, I'd like to turn to another document I provided yesterday. This one's titled The Potential for Load Flexibility in Xcel Energy's Northern States Power Service Territory.
Moving around, hang on.
Thank you. Mr. Haggard, are you familiar with this document?
Yes.
And this document was also prepared by the Brattle Group, correct?
Again, colleagues of the Brattle Group. It's just a company policy that there's not Brattle reports, but by each of the experts.
So I'd like to turn to figure 1 on page 3. That's PDF page 14 of this document. Mr. Haggerty, figure 1 shows that in 2017, Northern States Power had 850 megawatts of demand response capacity, or approximately 10% of system peak demand. Is that correct?
That's what it says here. I can see that it's, yeah, it looks like based on the number in the source, it would be about 10%.
Thank you. Now, if we could turn to figure 5 on page 16, that's PDF page 27. So, Mr. Haggerty, your colleagues at the Brattle Group identified an additional 293 megawatts of demand response that NSP could cost effectively implement by 2023. Is that correct?
That's what the document says, yes.
Thank you. Your Honor, I'd like to offer this document as Exhibit WEPCO Haggerty 21.
Any objections? Okay, it's in.
Thank you, Mr. Haggerty. No further questions.
Okay, let me just go off the record for a second and adjust my notes here. All right. Any other cross for this witness? No one? Give you a minute here. No. All right. How about redirect?
Yes, Your Honor, a little bit. If we could stay on this exhibit and go to page 8 of the PDF.
Okay. Oh, okay. Page 8 of the which PDF?
The one we're looking at right now.
Oh. So this is the PDF page number. Is that what
Yeah,
you're...
correct.
Okay.
That's perfect. Mr. Haggerty, on cross, you were asked about this study concerning demand response in Excel's service territory. Do you recall that?
Yes.
Please direct your attention to page 8 of the study, and could you please read the first full paragraph on that page?
This study also takes a detailed approach to assessing the cost effectiveness of each DR option. While emerging DR programs introduce the potential to capture new value streams, they are also dependent on technologies that in some cases have not yet experienced meaningful cost declines. Further opportunities to create value through DR vary significantly from one system to the next. A detailed assessment of the costs and benefits of each available DR option is necessary to identify the DR DR portfolio that is the right fit, in quotes, for a given utility system.
Is that consistent with your testimony in this case concerning demand response?
Yes, that is consistent. As in my rebuttal testimony, I noted the diversity of DR resources that exist and the need to study, the specific capability and the costs of demand response in each service territory, similar to this study for the Excel Minnesota service territory.
The two studies that Attorney Cordy showed you are several years old at this point, is that right?
I believe so.
Are you aware of more recent studies having to do with demand response published by MISO?
I'm familiar with some work that they've been doing to quantify the capability of demand side resources. Yes.
I'm sorry, demand.
Demand
What?
side resources.
Thank you.
Your Honor, I'd like to pull up two of the documents that we provided as potential exhibits. They're the two MISO documents.
You can see the workshop item is one.
Yep, that's one.
Take that one. Take that one first.
And sure, and if possible, we're going to talk about them both together because they're related.
All right. What's the other one called? Let me just. I have just the screen file name.
Demand response and emergency resource. Oh, LMR white paper.
There we go. Thanks. Okay, there we go. So those two. Okay, got it.
Mr. Haggerty, are you familiar with the two documents that we're looking at, one of which is entitled Market Redefinition, Demand Response and Emergency Resource Reforms, and dated January 30, 2025. It appears to be a MISO publication. And the second of which is entitled Demand Response and Emergency Resource Reforms White Paper, version 3, dated January 2025, and which also appears to be a MISO resource.
Yes.
Could you please describe the documents in broad terms?
Yeah, my understanding is that these are MISO documents related to their current attempts to define demand response programs and their ability to support resource adequacy in the MISO market.
Did you submit an earlier version of the white paper as an exhibit to your rebuttal testimony?
I did.
And have you reviewed these documents?
I have.
They're long papers, obviously, but without going into great detail, could you describe their principal recommendations?
Their principal recommendations are to define several categories of load modifying resources and demand response resources. And for each of those types of resources to specify how they participate in the capacity market and the energy markets, how often they would need to be called, for how long they would need to be sustained, as well as testing that needs to be done to ensure that those resources can support resource adequacy in MISO. My understanding is that this is more stringent than previous requirements for these resources in order to ensure as resource adequacy needs change in MISO, that these types of resources can provide the capacity that they claim, and that these more stringent requirements are likely to reduce the contributions of demand response in the MISO market.
Your Honor, I would ask that these two resources be admitted to the record as Haggerty 22 and Haggerty 23.
Okay, any objections? So they're in, and we'll call the demand response and energy resources reforms white paper Haggerty 22. And the market redefinition document will be Haggerty 23.
Thank you, Your Honor. Nothing further.
All right. Okay, thanks very much. So we're all done with this first witness. Thanks very much. You're excused. So I do want to note that I don't think I mentioned the SRSA rebuttal documents and the related exhibits need to be filed in IRF now that we've accepted them. So just want to make sure we note that.
Will do, Your Honor. Thank you.
All right, thanks.
We're going to do a little musical chairs here.
Okay. Get this right.
Ms. Phillips, are you going to be questioning?
I am, yes, thank you.
There's
Could
two
you move-
L's. Do you have two L's in Phillips?
I do have two L's.
Okay, good. Don't want to shortchange you. And who do we have in the witness seat?
We have Ms. Jarmus.
Jarmus. Okay, I think we got that. All right, excellent. I'm ready to go. Are you guys ready to go?
Ready?
Swear you in, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, we're all set.
All right, Ms. Jarmus, can you state your name for the record?
My name is Laura Jarmus.
And for purposes of this proceeding, did you prepare or cause to be prepared direct and rebuttal testimony along with one errata that we pre-filed?
I did.
Is that testimony true and correct to the best of your knowledge?
Yes.
Ms. Jarmus is available for cross-examination.
All right, who has questions?
Your Honor, we indicated that we may have questions for this witness, but we do not. Thank you.
All right, anyone else? No? All right, thanks very much. You're excused.
All right, we'll call our next witness. It's Mark Maurer.
Hey, all set? Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
All right, could you please state your name for the record?
My name is Mark Mower.
And for purposes of this proceeding, did you prepare or cause to be prepared direct, rebuttal, surrebuttal, and surrebuttal testimony?
I did.
And is that testimony true and correct to the best of your knowledge?
It is.
Mr. Maurer is available for cross-examination.
Who has questions?
Your Honor, Clean Wisconsin does.
Okay, go ahead.
Morning, Mr. Maurer. On page 4 of your rebuttal testimony, you discuss additional costs associated with using alternative site 2 for the proposed project. Sorry, that's on pages 4 and 5, I believe. And on page 5, you say, quote, a 1-year delay of the in-service date would require Wisconsin Electric to procure replacement energy and capacity from the market at an estimated 1.5 million for energy and 3.5 to 7 million for capacity. Are those figures net of fuel costs or gross costs?
I do not know.
Do you know if they account for the savings to ratepayers of delaying the plant and revenue requirement for a year?
I do not.
Thank you. No further questions, Your Honor.
All right, any other cross? Nobody? Redirect.
Yes, Your Honor, we have just a couple of redirect questions for Mr. Maurer.
Okay.
Mr. Maurer, you were asked some questions about your testimony on page 5 related to energy and capacity. Do you recall those questions?
Yes.
Do you know who perhaps here, what witness could answer those questions here?
I believe Brandon Gerlikowski could answer those questions, potentially.
All right, thank you. Nothing further.
All right, thanks, you're excused.
Just popping in to say we're shuffling.
Don't want any dead air. Yeah, there you go. I'm gonna take the pin off of you, Attorney Cordy. Oh, I don't know if you guys can see that. It may just be my screen. Keep me guessing.
Applicant would call Mr. Brandon Gerlikowski to the stand, Your Honor. Mr. Gerlikowski, would you state your name for the record?
Just a sec. Just a sec.
Sorry. The dead air, Your Honor.
I can only go so fast. You don't want me just ranting, do you?
No.
All right, let's swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Excellent. Go ahead.
Mr. Gerlikowski, would you state your name for the record, please?
Brandon Gerlikowski.
Mr. Gerlikowski, did you submit direct rebuttal, surrebuttal, and surrebuttal in this case?
I did.
And subject to some corrections on the offered evidence list and some errata we filed, if I asked you the questions today, would your answers be the same?
Yes.
And Mr. Gerlikowski, did you prepare and cause to be submitted 8 exhibits along with your testimony?
I did.
And are those exhibits true and correct to the best of your knowledge?
Yes.
Thank you, Mr. Gerlikowski. Mr. Gerlikowski is available for cross-examination.
Okay, before we get to that, I don't have the errata listed, so I just want to note that for my list. Which round of testimony is that for?
My apologies, Your Honor. I think maybe we didn't submit for Mr. Gerlikowski. Intent is any corrections that we've discussed on the record today.
Oh, okay, but there are none. There are no corrections today. Okay. All right. Yeah. So who wants to ask questions, cross questions? Who do we have?
Your Honor, Clean, Wisconsin.
So as Cub have questions, we can go in order of the offered evidence list if possible.
I was not going to object if witness Cordy wanted to go forward, but Cub does have some questions.
Yeah, let's just take it in order if that's okay.
Okay.
All right, go ahead.
All right. Good morning, Mr. Gerlikowski. I'm Corey Singletary with the Citizens Utility Board. My questions are gonna be pertaining to the company's responses to the Commission's data request, PSC Watson KG Series 8. Those, my understanding, will be included in the Commission staff direct DRR exhibit. Are you familiar with those responses?
Yes, I am.
Okay.
So let me just go off the record a sec. Would it be helpful to present at least the public version? Because there's no data request exhibit. It's going to take me a minute to actually find that on Earth. So
yes, Your Honor. At a couple of points here, I think it might be helpful to point to a particular one. In fact, if we could maybe start by going to the narrative response, which is a PDF document to PSC Watson KG 8.2, which is PSC reference number 532430.
532430. That's the public version?
Correct.
Okay. Okay, looks like I got it. Oh, can you see that? Or should I adjust the screen?
I can see it.
You can, okay. Or can you read it, I guess is more.
Yes,
important.
I can read it.
Okay. All right. So it looks like we're in the right spot. Go ahead.
Just a sec. I want to orient myself in this particular document here. All right. If you can direct your attention to about, what is that? The third sentence in the first paragraph, or that's a little small, where it says the model runs assuming the proposed Paris, Rice, and individual OCTT units times 5 were available to be optimally selected between 2027 and 2029. Do you see that sentence?
Yes.
Okay. Subject to check, would you agree that that statement is included in the company's responses to PSC Watson KG 8.2 through 8.5?
Yes.
Okay. When it states that those two facilities, the Paris Rice and the Oak Creek units, as described there, are available to be optimally selected between 2027 and 2029, and all Oak Creek units do not have to be selected at the same time. Does this mean that the model was configured such that the Paris, Rice, and Oak Creek CT units could only be selected in years 2027 to 2029 and could not be selected in later years such as 2030 or 2031?
Yes, that's correct.
Okay. Can you identify any model runs provided in response to PSC Watson KG8 that include any Rice or CT unit additions after 2029?
I would have to look at the results to see what was added potentially after that date. I don't know that off the top of my head.
Would you have any reason to disagree or if I told you that none of the responses to PSC Watson KG8 included Rice or CT units after 2029?
Objection, Your Honor. He just stated he would have to look at the modeling results to testify about.
Okay. All right.
Let's have him confirm in particular, though. That's fine. Go ahead and answer.
Could you repeat the question?
Well, let's read it back.
And I might not get these numbers right at the end there. Any reason to disagree if I told you that none of the responses to PSC Watson KG8 included Rice for GA units after 2029? KGA units?
Rice or CT units after
Rice or
2020.
CT units?
I would have to, subject to looking, I would say that may be a correct statement.
Okay. So you had indicated earlier that at least with respect to the model runs where it indicated that the units were allowed to be selected between 2027 and 2029, that was, would you, if I characterize that as a constraint to allow them to only be selected in those years, would that be an accurate description?
Yes, only those years.
Okay. Did the company attempt to run the model without this limitation?
No.
Okay. So in the model, staying with this one, KG 8.2, which limited new load to 450 megawatts. That was the scenario. Was the Paris Rice unit selected in any year?
Please define any year in that time frame.
In the model run, was it selected as a resource?
Yes, I believe it was.
Do you happen to know which year it was selected?
Again, I would have to take a look at the results.
All right. In the model run, I don't, because this gets into the spreadsheets a little bit. I can see if we can do it without going into closed. In the subsequent, in the next sort of run in the series, PSC Watson KG 8.3, which used the
can you
UCAP
repeat
reserve
that?
margin.
Wait,
Sorry,
can you
I can
repeat
slow
that
down.
number?
I can
In
slow
the next
down.
sort of run in this series.
PSC Watson KG 8.3, which used the UCAP reserve margin. Do you happen to know what date the Paris Rice facility was selected in that model run as a resource?
Again, I would have to look at the results.
Okay. Subject to check, would you agree that it was 2027, or would you have reason to dispute that it was 2027?
Again, I would have to look at the results.
Okay. So maybe cutting to the chase, looking when considering the results of the model runs responsive to PSC Watson KG 8.4 and 8.5. If I were to ask you questions about when the model selected an in-service date for the Paris facility, would your answer be the same? That you would have to check?
Your Honor, it's not up, and I'm not sure I understood the question.
Okay, I think the idea was cutting to the chase, but let's be a little more precise there.
Okay. All right. So, Mr. Gerlikowski, you had just indicated to me that when I had asked you what year what year the Paris Rice facility had selected as a resource to go into service under the scenario PSC Watson KG 8.3 that sitting here today you would have to check before you would be able to answer that question. Is that correct?
Yes, that's correct. I believe we ran 96 runs, so it's hard to remember every single one.
Okay. And with that in mind, I had some additional questions just because these were very late data request responses, and I wanted to try to get some clarity as to what were in there. If I were to ask you a similar question, if I were to ask you what date the Paris Rice facility was selected as a resource for in what year that would be placed into service under the scenario Watson KG 8.4 and Watson 8 KG 8.5, you know, would you need to check in order to answer those questions?
Yes.
Okay. Your Honor, I have some questions that I think will require going into close. They're related to some confidential exhibits related to gas capacity, gas supply capacity.
All right, that's fine. So let's go off the record. Do a bit of adjusting here. So we're going to put everyone. So as you see, the people on our participant list, it looks like parties only and their witnesses. I can create a waiting room, not a waiting room, sorry. Whatever it's called, a separate room where we will have, we'll put everyone in there. So therefore for that reason, we'll have the live stream going. It'll be blank. But it won't be connected for video or audio, but the Zoom will continue in the breakout room so that so that we can see and hear everything. So let me.
So, Your Honor, before we kind of get broken up here, I'm not 100% sure that all of the participants have signed the NDAs.
Yep.
And have
Okay.
access to confidential information.
All right.
So before we start asking questions, I guess I would want to confer. And make sure all the right
We'll check that. Well, I think it may be. So take a look at the list and see who may not be able to join us. I think I can.
And Patrick, on behalf of WEG, I sent back just this morning the confidentiality agreement signed.
Oh, thanks, Steve.
In the event that I'm not on your list yet, probably.
There we go.
I have to adjust this so I can see all the participants. Apologies.
So what I can do is let people choose to join. There's 33 people right now people are staff is trying to get in here. I can't imagine why they're coming in now. So let me put them in before we change, but I can let people choose to join, and then we'll at least get people who understand that they can't view the confidential can choose not to join. But before we go into questioning, we'll double check and make sure we only have people who should be in there. So you may be getting some sort of question whether you need to join or not. I'm not on your end. So on your end, you'll probably see some question. Do you want to join the room? So I'm going to do that now. And we should be back online in a second.
Judge Newmark, this is Tom Miller from the city of Milwaukee. The city is not a party to the NDA, but I'm also not seeing the option.
Yeah, I haven't pushed the button yet. Sorry. I'll just do that right now. This should be, maybe I can actually. Yeah,
Room 1, Your Honor.
close all.
If you click join breakout room down at the bottom of
Do you
the
see that?
screen,
You're seeing that now?
there's an option down there, join breakout room, and then you pick the one.
Okay, so that's what you guys need to do. Looks like some people are choosing now. Okay. All right. Haven't done this in a while, so I'm glad it's working so far. Can't find my selection. It's really odd. Okay. That's weird. It may just be you and me, Tom. Why not? That's weird. Okay, looks like I closed you out of the room.
Okay,
So we're
looks like I
back.
closed you out of the room. So looks like I closed you out of the room. Looks like I closed.
Well, live stream's working. All right. So everyone back, we still people waiting to get into the, that's odd. Thing clicking the cub. Okay, we have everyone back here. All right, so let's move on. We have our court reporter, we have Clean Wisconsin and WEPCO, our witness. So let's get started with Cross, more Cross.
Meeting button. Apologies for that. But yes, we're ready to go. If you can hear me.
Yes. Yep. I think we're all here together. So let's start with Clean Wisconsin's Cross.
Hello, Mr. Gerlikowski, Brett Cordy with Clean Wisconsin. Applicant's counsel indicated that you would have potentially have answers that I asked of Mr. Maurer a bit ago. So I'm going to ask you some questions about his testimony. On page 5, Mr. Maurer, of his rebuttal testimony, Mr. Maurer said, a 1-year delay of the in-service date would require Wisconsin Electric to procure replacement energy and capacity from the market at an estimated $1.5 million for energy and $3.5 to $7 million for capacity. Are those figures net of fuel costs or gross costs?
Net.
Thank you. And does that account for savings to ratepayers of delaying the plant and revenue requirement for a year?
Those figures are the energy and capacity costs for delay.
So it does not account for savings to ratepayers in the revenue requirement for a year?
Those figures do not calculate or bring in any delay in revenue requirement.
Thank you, Mr. Gerlikowski. No further questions, Your Honor.
All right, thanks. Do you have any redirect?
No, Your Honor.
Okay, any further cross from other parties? No one. All right, thanks very much. You're excused.
Thank you.
Applicants call Rich Stasek.
Here. Spell your name, I think. Got it wrong in another document there, but all right, great. So let's swear you in. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
Okay. Let's go ahead with this witness.
Please state and spell your name.
Richard Stasek, R-I-C-H-A-R-D, middle initial F, S-T-A-S-I-K.
Mr. Stasek, did you prepare and cause to be filed direct rebuttal, surrebuttal, and surrebuttal and accompanying exhibits in this case?
I did.
Do you have any corrections to your testimony?
I believe we filed some errata for my rebuttal testimony, if I remember correctly.
Yeah, on the errata, any corrections?
No.
If I asked you the questions contained in your testimony today, would your answers be the same?
They would.
Mr. Stasek is available for cross-examination.
All right, do we have any questions?
Your Honor, if we're going in alpha order again, Cobb has some questions for Mr. Stasek.
All right, great. Yes, let's do that.
And at the risk of being the problem child, we have some questions regarding his Sir rebuttal, which is a lot of the substance of it is confidential.
Okay, not a problem. We can handle that. Let's do our do-over. I think this might work easier this time, except let's go off the record anyway. That'll help. First things first. Huh. Oh, it looks like there's people still in a breakout room. How's that? No, you're not there yet. I'm just going to move everyone. This is the main session, right? Okay, let's try this again. I'm gonna assign everyone. So let me ask Attorney Wilson. I'm just gonna assign people to the breakout room. I think so I'm leaving out Cop and Miller. And also John Holloway, Town of Paris, I'm assuming is not an NDA.
Yeah, I'm just looking at our cross-referencing our list here. I think that's right, Your Honor.
And only engineering staff need to come in for commission staff side. So we have a Shepard, Chang, and Caleb.
Yeah, don't understand what's going on here. Recreate. Just one. I don't know. I have like 2 rooms going on somehow. Okay. I think this will work now. No, mutes everyone when we switch. So yeah, we're back to the main session and we can start. I think Agent Singletary has a question still for public.
Yeah, a couple more questions. If we could bring up the public version of Mr. Stasik's Sir rebuttal testimony.
Sir. So I think I don't have that in front of me here. I think you'll just have to rely on your copies that you have with you.
Mr. Stasik, do you have a copy of your Sir rebuttal in front of you?
I'm just getting that back from earlier. Yes, I have it.
Okay. Beginning on line 11 of page 3 of your Sir rebuttal, if you could direct your attention there.
Yep, in there.
You're responding to witness Burgess's testimony as it relates to sort of different load forecasts that came from different time periods, specifically an April 4th and a a March 22nd, 2024 and a September 30, 2024. Is that correct?
Yes, sir. Okay.
And in your testimony, you indicate that while Mr. Burgess is correct that an April 4, 2024 forecast was used to do Plexos modeling supporting the application in this case, the second forecast was actually from September 30, 2024, not from March 2022, 2024. You see that?
I do.
Okay. Has the company presented any Plexos modeling results that are in the record that use the updated September 30, 2024 forecast?
Not that I'm aware of, no.
Okay. Has the company sought to amend or refile any elements of its application in this case with the updated forecast?
No.
Okay. No additional questions from Cup. Thank you.
All right, thanks. Any other cross? Nobody? How about redirect on those last questions?
No, Your Honor, but we have one more staff cross question, I guess.
Oh, okay. Yeah, go ahead.
Mr. Stasik, could you please explain the applicant's brownfields approach to brownfields in connection with this facility?
Yes. As company personnel developed this project, the siting evaluation included looking for brownfields within a reasonable distance of the proposed site at the existing Paris generation site and evaluated the cost effectiveness of each. Based on that initial evaluation, it was determined to use the site closest to alternative site 1 because this site had some characteristics of a brownfield or could be considered a brownfield if decommissioned.
Nothing further, Your Honor.
All right. There we go. So you're excused. Thanks very much.
Thank you, Your Honor.
And do we have any other applicant witnesses on the docket here?
No.
Oh, looks good. All right. So let's take let's say half an hour break.
Actually, Judge, we have a request to take Judy Rademacher early. Her kid is sick and she needs to bring to go to the doctor. So if we could request verifying, I don't believe anyone is planning to cross. We can ask again, but
oh, I'm losing your audio somehow.
I think I just dropped off. Can you hear me?
Yes, yes.
Sorry.
I don't think this will be complicated, so we can take her first and then take a break.
Thank you.
So let's call Jury Rademacher. See you there.
Yeah, thank you for accommodating.
Yeah, sorry to hear about that. So yeah, raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
Yes.
Okay, go ahead.
Okay. Please spell your last name for the record.
Radermacher.
What is your position at the Department of Natural Resources?
I am a water management specialist within the Office of Energy.
How were you involved in this docket?
I reviewed the project for waterway and wetland impacts and contributed to the EIS.
Did you cause to be filed or file or cause to be filed? And I'm just scrolling back to the. I'm seeing direct and errata testimony from you. Did you cause?
Yes.
Thank
Yes.
you. And aside from, actually, sorry, trying to catch up. I see a few typographical errors noted by the judge. Aside from those, are the statements and representations in your testimony true and correct?
Yes.
Do you have any additions or modifications at this time?
I do not.
Okay, open for cross.
All right, are there any questions? Okay, don't hear any, so thanks very much. You're excused.
Yeah, thank you.
All right, take care.
Good luck.
All right, so we'll hit a half-an-hour break. 1:15 we'll be back. All right, thanks very much.
Thank you.
All right. Oh, how quickly time flies. So I don't know if everyone got my email. It looks like Clean Wisconsin's okay with calling Jester now. I think that would be a good thing because of the time constraint that that person indicated. So let me just see if we have everyone here. Ah, I see you there. Okay. All right, great. So let's get started.
So, Your Honor, if you don't
yeah.
mind, I have I don't know, announcement is the right word or not, but we're not going to cross-examine Mr. Holloway. So to the extent that changes his plans, we're happy to have him be released at this point.
Okay. Thanks for updating that. Yeah, so why don't we quickly just ask if there are any other...
Are you on the record?
No, we can be off the record.
Okay.
Any intention to cross Holloway from other parties? No? All right, great. All right, yeah, let's go on the record. So I just wanted to mention we're going to be able to release witness Holloway from further attendance if that person wishes to file documents by affidavit, verify their documents by affidavit, we can accept it. Otherwise,
some clarifications that we're going to ask him. So,
okay, you're calling him anyway. All right, no worries. All right.
I'm sorry, who said that?
this is Attorney Jared Walker Smith for the town of Paris.
Just don't see you. Okay.
Right here.
Oh, that's why. The little blip in the corner there. Sorry about that.
No worries.
All right, so at this point, we're going to call Clean Wisconsin's witness Jester. And let's go ahead. I'll swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, go ahead, Attorney Cordy.
Good afternoon, Mr. Jester. Could you please state your name for the record?
My name is Douglas Jester, Jester.
Mr. Jester, are you the same Douglas Jester that prepared and caused to be filed direct and surrebuttal testimony and associated exhibits in this docket?
Yes.
To the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes, with one correction in my direct testimony.
Could you explain that correction?
Yes, it is on page 8 of the testimony, line 4. The word approved in that line should be replaced by under consideration by. Excuse me, just under consideration by is already there.
Thank you, Mr. Jester. Are there any other corrections?
No.
Thank you. The witness is available for cross-examination.
Okay, do we have questions? Start with the applicant and then go down the list of offered evidence.
Thank you, Your Honor. Our applicant has some questions for Mr. Jester.
Okay.
Good afternoon, Mr. Jester. My name is Attorney Patrick Proctor Brown, and I represent Wisconsin Electric Power Company. We haven't met before today, right?
That's correct.
Fair to say you have some testimony on reliability in this case. Would that be true?
Did you say reliability?
Yes.
Yes,
Did you review Mr. Arndt's rebuttal testimony in this case?
I believe that I did.
Judge Newmark, if you could bring up page 10 of Mr. Arndt's rebuttal testimony, I think that would be helpful.
All right, just give me a second here. End of rebuttal, you said?
Yes, rebuttal.
Public gonna work?
Yes.
Okay. Hoping you'd say that. In the right spot?
Yes, Your Honor, thank you. And so, Mr. Jester, do you see page 10 of Mr. Arndt's rebuttal testimony before you?
Yes, I do.
And I think it's fair to say this page through page 15, Mr. Arndt is discussing reliability concerns expressed by the North American Electric Reliability Corporation, also known as NERC, Reliability First, and MISO. Would you generally agree with that?
Yes.
What is NERC, to your understanding?
The North American Electric Reliability Corporation is a nonprofit organization sanctioned by the Federal Energy Regulatory Commission to perform studies and propose standards or regulations that would apply to participants in the bulk power system.
I'm sorry, participants in the
Bulk power system.
Thank you.
Would you agree that NERC's mission is to assure the effective and efficient reduction of risks to the reliability and security of the grid?
Yes.
NERC is a credible source on the issue of grid reliability. Would you agree?
Yes.
What is reliability first, to your understanding?
It is a regional organization also sanctioned by the Federal Energy Regulatory Commission that is responsible for assessing reliability in certain portions of North America.
And Reliability First has delegated authority from NERC, correct?
Yes.
Reliability First is a credible source on issues of grid reliability, correct?
Yes.
Do you consider MISO, the Mid-Continent Independent System Operator, to be a credible source on issues of grid reliability?
Yes.
Do you have any basis to dispute Mr. Arndt's description of NERC's and Reliability First concerns about reliability in MISO, as addressed in these pages of his testimony and the exhibits to Mr. Arndt's testimony?
No, I do not.
Do you have any basis to dispute NERC's views on the importance of natural gas generators for reliability, which is discussed at Arndt 13?
Can we scroll forward to that, please?
Mr. Jester, do you see in the middle of the page the question and answer and the bold text that's quoting from an exhibit developed by NERC?
Yes, I do see that.
And the quotation is, natural gas-fired generators are a vital grid resource. Did I read that right?
Yes.
Do you have any reason to dispute that view from NERC?
Not as expressed by NERC. I believe that statement was made in context of the existing resources in North America.
You don't dispute that NERC said that statement, that natural gas generators are a vital grid resource?
I do not.
And Mr. Jester, turning to the topic of energy efficiency and demand response, do you have that topic in mind?
Yes.
Is it your position that energy efficiency and demand response are potential alternatives to the Paris-Rice project?
They are potential elements of a resource portfolio that could either substitute for a portion of the Paris project or for other reliability resources.
So it's not your position that the Paris-Rice project can be avoided simply through enhanced energy efficiency and demand response. Is that true?
That depends on the projected load in which the assessment would be made.
Right, and you have not testified under any potential load that the Paris-Rice project can be replaced simply through energy efficiency and demand response. Was that a fair summary of your testimony?
I believe I've testified that the Rice project, the Paris Rice project, may not be necessary in the absence of the projected load growth.
I'm sorry, may not be necessary.
In the absence of the projected load growth,
Thank you.
and that is independent of whether energy efficiency and demand response are considered.
Would you agree that Wisconsin's statewide focus on energy program has been effective?
I am not familiar in detail with the focus on energy program.
So you just don't take a position on the effectiveness of the focus on energy program? Is that your testimony?
My knowledge of its effectiveness would simply be by reputation, not from direct examination.
Okay, what's the reputation of the focus on energy program to your understanding?
That it is effective at a modest scale.
The effectiveness of any energy efficiency program, including the focus on energy program, ultimately relies on the actions of consumers, correct?
Yes.
Energy consumers need to take action and participate in any energy efficiency program for it to work, right?
Yes.
The utility cannot mandate participation in an energy efficiency program, true?
That is true.
The utility has to rely on consumers to take action outside their control, correct?
Outside, by there, do you mean the utility?
Yes.
Yes.
And the same is true of the commission, correct?
Yes.
The commission can't mandate that consumers participate in energy efficiency programs, true?
That's true.
You would agree that consumers also have to take action for demand response programs to work, correct?
There was a brief loss of audio. Did you say demand response programs?
I did, yes.
Yes.
Consumers need to opt in to a demand response program in sufficient numbers for the demand response program to be effective, correct?
Yes.
The utility cannot mandate participation in a demand response program, true?
The utility can offer certain tariffs subject to participation in a demand response program. And I'm not clear under those circumstances what you mean by mandate.
The tariffs that you're referring to, a consumer would need to elect to participate in that tariff, right?
Based on my understanding of the tariffs currently offered by Wisconsin Electric Power Company, yes. That does not mean that there could not be a tariff, a type of customer who's obligated to participate in a tariff that includes demand response.
So it's your position that the utility can order particular customers to participate in demand response programs?
The utility could offer tariffs that mandate that participation for certain types of customers, yes. Subject to the commission's approval, of course.
But the choice to participate in those tariffs would ultimately be the consumer's choice, right?
Only if the utility offered an alternative tariff that did not require participation in the demand response program.
Just like energy efficiency, the utility has to rely on consumers to take action outside the utility's control in demand response, right?
Yes.
I'll turn to the topic of firm demand and capacity planning. Do those terms make sense to you?
I had a little difficulty hearing the first part of the question. Please repeat.
Sure. So I want to turn to the topics of firm demand and capacity planning. Do those terms make sense to you?
Yes.
In your surrebuttal testimony, you discuss Microsoft Microsoft's load projections and contractual commitments on pages 2 through 5, correct?
Yes.
And you make some comparisons between the nameplate capacity of the Paris Rice and Oak Creek CT facilities to Microsoft's load forecast. Do you agree with that?
I do.
What does the term high load factor mean?
Load factor is the ratio of average load to peak load for an individual customer. So high load factor would be a customer who generally uses almost as much electricity at any given time as they do at their peak demand time.
So fair to say that a customer with a high load factor will have a similar demand overnight to their demand during the day, right?
Yes.
What does the term firm demand mean to you?
It refers to the terms of service to the customer, where they are committing to a certain level of demand and paying for that level of demand.
Are you aware that Wisconsin Electric has an obligation to serve the firm demand of all of its customers?
I am not familiar with all aspects of Wisconsin law, but I wouldn't be surprised if that is true.
Public utilities generally have an obligation to provide adequate service to their customers, right?
Yes.
And so if a customer said, this is my firm demand, that would trigger typically a public utilities obligation to serve that amount of demand, right?
Yes.
Can 450 megawatts of high load factor firm demand be served by 450 megawatts of nameplate capacity?
Generally not, because nameplate capacity is subject to failures and interruptions.
Right, so even a dispatchable resource will have some maintenance and outage periods over the course of a year, correct?
Yes.
Can 450 megawatts of high load factor firm demand be served by 450 megawatts of nameplate solar capacity alone?
Of course not.
Have you done any analysis to determine the generation and storage portfolio necessary to serve 450 megawatts of high load factor firm demand?
I have not done modeling specific to meeting 450 megawatts of firm demand.
Okay, thank you. Have you done any analysis to determine how Wisconsin Electric would serve 450 megawatts of high load factor firm demand if the commission denies approval of the Paris Rice and Oak Creek CT projects?
Would you repeat the question, please?
Let's have it read back.
Thank you.
Question, excuse me, question, have you done any analysis to determine how Wisconsin Electric would serve 450 megawatts of high load factor firm demand if the commission denies approval of the Paris Rice and Oak Creek CT projects?
No, I have not.
You state in your surrebuttal testimony on pages 3 and 4 that, and I'm quoting, the generation capacity for which Wisconsin Electric requests approval in this case and the Oak Creek CT Certificate of Public Convenience and Necessity totals 1,314 megawatts. In that quotation, you were referring to the nameplate capacity of those facilities, correct?
Yes.
You go on to say that 1,314 megawatts is substantially more than Microsoft's announced requirement for 450 megawatts for phase 1 and materially more than the demand referenced in Microsoft's current contract with Wisconsin Electric. Do you agree with that?
Yes.
Are you referring to anything other than a comparison between nameplate capacity and these two measures of Microsoft's demand?
No.
What is a capacity factor?
Capacity factor is the ratio of average production from a generation facility to its nameplate capacity.
Are you aware of the capacity factor that the US EPA uses to define a peaking natural gas facility?
Yes.
Would a 20% capacity factor cap be consistent with a peaking facility?
That is my recollection of what the regulation says, yes.
Would you agree with me that a facility with a nameplate capacity of 1,200 megawatts and a capacity factor of 20% is only producing about the same amount of energy as a 240 megawatt firm load requires?
That is about right for the average production from such a facility, but does not reflect its capability when called upon.
Because that 1,200 megawatt facility with a 20% capacity factor is not generating energy equally across all hours, right?
Correct.
So would you agree with me that planning to serve high load factor firm demand is more complicated than simply comparing the nameplate capacity of generating resources?
Demand by any one customer is usually served by resources in the entire balancing area or market area. My understanding is that WEPCO is a participant in the MISO market. So all of the power that would be supplied to Microsoft would be provided by that in the particular facilities constructed to meet WEPCO's resource adequacy obligations are really not relevant to your ability to serve the energy demands of this particular high load factor customer.
Just off the record for a second. Debbie, did you catch all of that statement? I thought I might.
It was breaking up, but I think, yeah, I think it came through okay.
Okay, all right. Let's get back on. Go ahead.
So I don't think that was actually responsive to my question. The question is limited to, is planning to serve high load factor firm demand more complicated than simply comparing the nameplate capacity of generating resources to the firm demand level? I think it's a yes or no question.
Yes.
Thank you. And you haven't done any analysis of your own to determine what portfolio of generation resources would be able to serve any of Microsoft's potential demands, correct?
Correct.
I want to move to another topic. And the term I'm going to use is BESS, which to me means battery energy storage systems. Is that what it means to you too?
It is.
And I want to focus in specifically on third-party arrangements related to BESS. Does that topic make sense to you?
It does.
In your rebuttal testimony, you include a response to Eric Nicholas on pages 8 to 10. We can wait for that to be in front of you, but do you recall that response?
Sorry, can you repeat that one more time?
Pages 8 to 10, Your Honor.
On which?
On his rebuttal,
okay.
Mr. Jester's rebuttal. We'll wait to get that up, and then I'll ask you a question about
it. I'm blanking on the page. You said 7 or no?
8 to 10. So
8
just
to
one
10.
more.
Oh, the whole thing. Okay. All right, there you go.
So, Mr. Jester, we have in front of you page 8 of your rebuttal testimony, and section 4 here says response to WEC witness Nicholas. Do you see that?
I do.
And if we go to page 10, Your Honor, if you don't mind. Mr. Jester, you acknowledge Mr. Nicholas's testimony that there are costs, complexities, and risks of third-party arrangements related to tax credits. Do you see that?
I do.
And right before that acknowledgement, you cite pages 10 to 11 of your direct testimony for the statement that, quoting, There are a number of alternative ownership structures that could provide Wisconsin Electric most of the benefits of a BESS investment tax credit. See that in footnote 34?
I do.
Have you done anything to quantify the term most used in that sentence?
Because the benefits are potentially an enumeration rather than quantities, I'm not sure it's a sensible question to quantify that.
Well, have you done anything to quantify the term most? I think it's a yes or no question, Mr. Jester.
Well, I don't think the word most implies quantification.
Okay, is your answer you have done nothing to quantify the term most as you used in that sentence?
Yes.
Thank you. If we look back at pages 10 and 11 of your direct testimony, and apologies for jumping around here, Your Honor.
No worries.
And this is the section of your direct testimony that you were just referring to in your survey testimony. You agree with me, Mr. Jester?
Yes.
It appears you're referring to the question and answer starting at page 10, line 11, and ending on page 11, line 6. Is that what you intended to refer to in your survey testimony?
Yes.
You point to 3 options here. Number 1, a tolling agreement. Number 2, a power purchase agreement. And number 3, simply purchasing the zonal resource credits from a BESS system owned and operated by a third party. Is that a fair summary?
Yes.
You don't cite any authority in this part of your testimony related to these 3 options, correct?
Correct.
You don't provide any examples of any agreements related to these 3 options, correct?
Correct.
How much profit do third parties take on these kinds of arrangements?
By profit, do you mean as a percent of investment?
Right. How much profit do the third parties take or earn, or whatever term you want to use, to enter these kinds of arrangements?
In part, that depends on the contractual terms between the third party and the utility and the level of risk that the third party thinks that they are incurring, which then determines how much of their investment is financed by debt and how much is financed by equity. So the answer is indeterminate without further details.
You don't contend that these third parties would enter these types of arrangements and not require profit, right?
Oh, no, not at all.
You just don't know, as you sit here today, how much that profit would be, right?
Because I don't know how much that profit would be. That's true. Yes.
Focus on your second option, where Wisconsin Electric, quoting, would pay for the energy outflow and zonal resource credits provided by the storage system. How much would that cost?
The cost can't be determined without knowing the size and characteristics of the facility and the operating agreement between the utility and the third party.
How much profit would the third party charge?
Objection, Your Honor. This calls for speculation on specifics that we're not talking about here.
It's his alternative that he's proposing in this docket. I'm asking him some pretty basic questions, frankly, about what that alternative would be.
He can answer based on his experience.
I have reviewed agreements between utilities and storage providers, battery energy system storage providers, that have a variety of different terms. So the pricing varies in those arrangements based on those terms. Without knowing the terms, I can't really say what the cost or profit would be.
So your second alternative, you don't know how much profit the third party would charge, right?
Because
Objection, asked and answered.
Just summarizing his testimony.
Go ahead and answer.
I can't answer that question because it would depend on terms that would be determined between, in this case, WEPCO and the third party.
The question was, you don't know. So your testimony just now is that you can't answer the scope of your knowledge? Is that how I should understand that response?
Objection, this is argumentative, cross.
I agree. Okay, let's move on.
Okay. Who pays to charge the batteries under your second option?
The arrangements can be either that the utility pays or that the third-party operator of the battery pays. One arrangement that I've seen is that the third-party operator pays for the battery, receives the revenue from the sales of the energy, and then the utility pays a fixed price for the difference.
What is the lowest internal return you have seen in such an agreement?
Because I have seen the contracts between the utility and the third party, not the internal analysis of the third party provider, I can't answer.
If I asked that same question about the highest internal return, you would also not be able to answer?
Correct.
How much was a ZRC, a zonal resource credit, in MISO last year?
The price depends on location and on whether you're talking about in the auction or in bilateral contracts. So there's no singular answer. And I do not recall the specific values from last year.
So you don't recall the specific values in the auction for a ZRC in any zone in MISO. Is that your testimony?
Yes.
What happens if Wisconsin Electric does not need to discharge the batteries to serve load? Your second option.
A battery operating in the MISO market would respond to instructions from MISO based on MISO's need for serving load and the prices offered from various resources, and would not in any way depend on WEPCO's need to serve load.
So it's your testimony that Wisconsin Electric would just be on the hook for whenever MISO directed the BESS facility to discharge into the bulk electric system?
Which is how all of WEPCO's generation and storage resources operate.
Well, that's not true, right? Because owned resources, customers get the benefit of the sale. Isn't that right?
Yes.
So a facility that's owned by a third party, you only get the liability of the purchase, none of the benefit of the sale, right?
That depends on the terms of the contract.
When we go to your third option, simply buying ZRCs from a BESS facility, Wisconsin Electric would not need to buy ZRCs from any specific BESS facility to purchase ZRCs to use in the planning resource auction, right?
They would not need to buy from any particular BESS facility.
Okay. You're aware that ZRCs do not provide any rights to capacity or energy, right?
Yes.
Are you aware of a BESS facility in MISO Zone 2 that is willing to just sell ZRCs in a bilateral contract?
I'm not aware of one that exists now, but
Okay,
it
thank you.
absolutely would be possible for WEPCO to enter into a contract to have one built under those conditions.
Right. There's no BESS facility that, as you sit here today, that you're aware of that is willing to sell ZRCs in MISO Zone 2, right?
Correct.
Did you develop any data at all about the price and availability of these different third-party arrangements?
No.
Can you point to any Wisconsin utility that has entered one of these three types of arrangements for BESS?
No.
Your surrebuttal testimony on pages 12 to 14. So sorry, Your Honor, if you could go back to the surrebuttal testimony, I'd appreciate it. So we're at page 12 here, Mr. Jester. Fair to say you refer back to Mr. Sieber's criticism of your direct testimony. Is that fair?
Yes.
Mr. Sieber notes that you appear to have repurposed a presentation you developed back in 2022. You don't dispute that at all in your surrebuttal testimony, correct?
Correct.
The data you used for that presentation was from the same site as a 2.4 megawatt O'Shea Park solar farm. Is that true?
It is.
And at the time your data was collected, there wasn't a battery operational at that site, correct?
Do we have a pending question or just thinking about that answer?
I didn't hear him say him answer. Sorry. Did
I didn't
you
hear
answer
an
the
answer.
question?
So do we need the question read back?
I think so.
Are you okay, witness Jester?
Yes.
Okay, I wasn't sure. All right, let's have the question read back.
Question: at the time your data was collected, there wasn't a battery operational at that site, correct?
Yes, that is correct.
What is the capacity of the quote unquote modest BESS installation now installed at that site?
That, if it is a quote of my testimony, is not in reference to a battery installed at that site. It was in reference to the hypothetical battery that I modeled.
I'm sorry, hypothetical battery.
That I modeled.
Thank you.
Well, just off the record, Attorney Proctor Brown, where was that modest statement? I'm having trouble finding it.
It's in his direct testimony, Your Honor. I don't know if we can go back to that. I believe it'll be kind of in the middle of his testimony.
Page 13, near Detroit. Is that what we're talking about?
Yep.
Okay, let's get back in the record. So I think the question that was posed to the witness was referring to direct CW Gesture 13, line 20, the modest battery near Detroit. So let's proceed from there.
Thank you, Your Honor. Mr. Jester, you have in front of you page 13 of your testimony. And if you see on the last line, it says, which is the site of a modest battery near Detroit? Do you see that testimony? And my question was, what is the capacity of the modest, quote unquote, BESS installation now installed at that site? Do you have an answer to that question?
I do not. I don't recall.
Do you know when that modest battery was installed?
My recollection was that at the time I did the presentation, it was expected to be installed in early 2023.
Okay, and did you follow up on that installation after you created this presentation back in April of 2022?
No.
So you have no knowledge of the actual battery that exists at the node that you're referring to in your testimony. Is that right?
That's correct.
Have you actually operated a BESS facility in accordance with one of the algorithms you used in your 2022 presentation?
No, I have not.
Do you have any experience operating a BESS facility?
As an operator of batteries?
Yes.
No.
So your testimony is all based on an April 2022 15-minute presentation and your theoretical analysis of battery operations. Is that fair?
No, it's not fair. I used data from that presentation to illustrate a point. But my personal experience analyzing storage operations extends over a substantial period of time. In 1994,
Sir, I didn't ask you anything about your experience in 1994.
You
Have you
asked
ever
about the
operated?
experience.
No, I did not. I did not
Off the
ask
record.
anything about
Let's
that.
go off the record. Make sure we speak one at a time. Okay, so we can just keep our emotions low here and continue on, but one at a time, please. All right, so we had
Your Honor, he's attempting to go completely back to his own experience from 1994 on a pretty simple question. And I'd just like to move on to my next question, and then we can be done with this line of questions.
Your Honor, Attorney Proctor Brown asked about the witness's experience with this, with what he's testifying about. If it happened in 1994, it's as relevant as anything else.
Okay.
I did not ask about his experience back to 1994.
All right. Well, we do have his witness's experience in the record, showing the direct testimony. I'm not sure if we have a CV. Is that just for one usually? So those documents are going to speak for themselves unless we have some specific questions we want to ask on that. I mean, I mean, to be generous, I think we weren't talking about the context of BESS facilities, so I'll give the applicant that much, but I don't think we need to beat this to death. So we do see a number of experience listed here in the CV. So I don't know if there's anything specific you'd want to ask about that, Attorney Proctor Brown.
I didn't have any questions about his CV specifically. I just have one more follow-up question. That's
Okay.
not.
So let's get on the record for the last question.
Mr. Jester, fair to say you have not done anything to evaluate the performance of the battery at the site that is the subject of your testimony. Is that true?
By the site that is the subject of my testimony, the DECO.O'Shea.bat node.
I don't know if he broke up or I didn't understand.
Yeah, can you just repeat your answer, Witness Jester?
I was asking whether by the site referred to in my testimony, you meant the DECO.O'Shea.bat node.
Yes, the same site as the O'Shea Solar Park.
I've not evaluated a battery after it was installed.
Thank you. Yeah, that's all I had.
All right, great. Any other cross? Okay, I'll have redirect.
Thank you, Mr. Jester. Can you give a brief overview of your experience with modeling battery and energy storage systems?
Yes.
Could you please provide that?
Of course. In 1994, I served as the lead expert witness for the state of Michigan in a number of cases to do with the Ludington pumped storage plant, which is not a battery, but is an energy storage system. And as a part of negotiating a settlement between the state of Michigan and the owning companies, Detroit Edison and Consumers Energy, I analyzed the effects on operations and value of the Ludington pump storage plant of an adder, proposed adder, by which they would compensate the state for fish killed when pumping or charging that energy storage system. In 2010, I did work for General Motors and Hitachi. They were considering what it would take to modify batteries removed from vehicles and repurposed for grid storage, and wanted to know what the operations would look like. And I modeled optimum operations of such a battery system in response to grid prices for them. In 2014, I, together with one of my colleagues at Five Lakes Energy and Professor Jeremiah Johnson and a couple of graduate students at the University of Michigan, developed a modeling system for evaluating compliance strategies for the Clean Power Plan. And that included both pump storage and battery energy storage systems as resource options. In 2020, another colleague and I used the commercial software system Homer to model optimum combinations of solar and battery storage systems for a large Michigan-based manufacturer that was interested in having such systems at its manufacturing sites. In 2022, I provided modeling and report elements related to that for a roadmap for battery energy storage systems prepared for the State Energy Office in Michigan. And then in 2023, made further modifications to that storage modeling system in order to assess the level of storage that would be required to meet Michigan's renewable energy standard that was under consideration by the state legislature.
Thank you, Mr. Jester. Do you recall being asked on cross about a statement in Mr. Arden's testimony that repeats NERC's assertion that natural gas-fired generators are a vital grid resource?
I do.
In your opinion, do you think NERC was implying that only natural gas generators are a vital grid resource?
Your Honor, calls for speculation.
Overruled.
And no, I did not read NERC's statement as implying that only natural gas power plants were acceptable as resource adequacy resources.
Thank you. And do you recall being asked whether customers must take action in order to participate in energy efficiency programs?
I do.
Do you have any reason to believe that this requirement would prevent WEPCO from achieving additional energy efficiency savings in its territory?
I do not see that as a barrier. many utilities offer rebates and other forms of assistance to customers and achieve very high levels of participation, resulting in reductions in both capacity and energy requirements.
Thank you. Is it true, regardless of service territory, that energy efficiency programs must be opted into by customers?
I guess I didn't understand your condition regardless of service territory.
Yeah, so is it true that energy efficiency programs in any utility service territory must be opted into by the customers generally?
Oh yes, yes. Mhm.
What is your sense of how focus on energy efficiency savings stack up to the best performing utilities in the MISO footprint?
Mhm. I believe that the current level of performance is about half what is achieved by the top performing utilities. That's as measured by incremental annual savings.
Thank you. So, Mr. Jester, given everything you've read in the applicant's sir rebuttal, and what you've heard today in today's hearing, have your recommendations to the commission regarding WEPCO's application of this docket changed?
Your Honor, objection. This is beyond the scope of the cross.
I'm simply asking him if anything has changed in his recommendations since sir, which we did not file.
Okay, well, it could also be whatever he heard or was questioning on cross. So I think that's
exactly.
So go ahead and answer.
No, my recommendations do not change.
Thank you. No further questions, Your Honor.
All right, thanks. All right, you're excused, and we can
Apologies,
move
Your
on.
Honor, but could I'd like to ask him about the paragraph, multiple paragraph answer that he talked about BESS operations, if you don't mind, just a handful of questions.
In what way?
I just have a couple of questions about his answer about his experience with BESS. He was allowed to testify at length about his experience with BESS, and I'd like to ask a couple of follow-up questions based on that testimony.
I don't think so. I think we're going to move on. I think he was responding to cross regarding a question that you raised.
Yeah, and that's very typical to have recross after he
yeah,
adds information
I think
to the record.
We're just dancing on a pinhead here. So I don't think there's really anything that's going to be more elucidative in that questioning.
But respectfully, Your Honor, you're not the decision maker, and I have the right to make a record. He testified at length about his experience on redirect, and I have 2 or 3 follow-up questions that I think would be helpful to the commission if you would answer.
Your Honor,
yes,
I believe most, if not everything, the witness testified to in that answer was included in his resume, and the
It wasn't, though. It wasn't, but he talked about 4 or 5 different projects that weren't on his resume, and I just have a couple of follow-up questions. I'm surprised we've now spent more time arguing about it than my questions would take.
Well, we'll see about that. Yeah, I'll say that they were not included in the resume. I was trying to track that. So, all right, we'll do some brief questions. Recross.
Thank you, Your Honor. Mr. Jester, do you remember your questions and answers about your experience with BESS on redirect, I'm sorry?
Yes.
And I believe you listed 4 or 5 or 6 different topics in that answer. Is that kind of a fair summary of your answer?
I suppose. Mm-hmm.
Were any of those topics operational BESS systems, or were you doing prospective analysis of BESS?
Those were all prospective analyses of BESS.
They were all about hypothetical operations of a BESS system. Isn't that true?
Well, with the exception of the Ludington Pump Storage Plant, which is not BESS, but is a storage system.
So I believe your testimony today is you've never operated a BESS system and you haven't done any analysis of an existing BESS system. Is that true?
Yes.
Thank you. Thank you, Your Honor.
All right, let's move on to our next witness. So I think we're going to switch back to Cub or invite Cub to testify.
Can I ask a question of the witness?
Oh, yeah, go ahead.
Just the software he mentioned?
Oh,
Like
yeah, right.
Boomer or something, or?
The name of it is Homer, Homer.
Homer. Okay, thank you. Sorry for the interruption.
No, that's great. I'd forgotten about that. So let's call Cub and their witnesses.
All right. Cub calls Edward Burgess to the stand.
Hi there. Can you hear me okay?
Yes, I'm just going to see if I can find you here. There we go. Okay, and we have Attorney Goldschmidt. All right, great. Let me swear you in. Raise your right hand. Swear or affirm, tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, go ahead.
Good afternoon, Mr. Burgess.
Who's speaking?
Good afternoon.
So that's Corey Singletary.
Oh, that's what I thought. You said Mr. Goldschmidt. That's what threw me off. I thought it was. Okay.
I just, yeah.
Good afternoon, Mr. Burgess. Corey Singletary from the Citizens Utility Board. Can you state and spell your name for the record?
Yes, my name is Edward Burgess, EDWARD BURGESS.
And did you prepare a cause to be filed direct, rebuttal, surrebuttal, testimony, as well as 31 exhibits?
Yes, I did.
Okay. And if asked the same questions in your testimony here today under oath, would your answers be the same?
Yes, they would.
And are the exhibits true and correct to the best of your knowledge?
Yes.
Okay. I have a couple of questions. Were you present during the cross-examination of WEPCO witness Gerlikowski?
Yes, I was.
Okay. And do you recall the questions I asked him about some late data requests regarding sensitivities requested by commission staff?
Yes.
Get the name. Yes. Okay. All right. And when I asked him, I believe it would be fair to characterize as Mr. Gerlikowski indicated that when I asked him if he knew whether or not the Paris Rice facility was selected under the sensitivity 8.2, he indicated that it was. Is that consistent with your understanding of the results of that sensitivity?
No, if I reviewed the response to that data request, which indicates that the Paris Rice unit was not optimally selected in the model run responsive to 8.2.
Okay. Have you had the opportunity to review the results for sensitivities under PSC Watson KG 8.3 through 8.5?
Yes, I have reviewed those.
Okay. And I'm just going to truncate it to the number in the sensitivity run under 8.3, which used the UCAP reserve margin. Are you aware of what date the Paris Rice facility was selected based off your review of the results?
Yeah, based on my review and my interpretation of the model results, the Paris Rice unit was selected in December 2027.
Okay. And then moving to 8.4, which used the DLOL as part of that sensitivity, were you able to determine in your review what date or I should say what month the Paris Rice facility was selected?
Yes, it was selected in December 2028.
Okay. And moving to 8.5, would you agree that the sensitivity run under that data request from staff, 8.5, combines all of the updated assumptions from 8.2, 8.3, and 8.4?
Yes, that's my understanding. It combined all of those 3 prior runs modifications.
Okay. And under that combined model run, were you able to determine when the RICE facility was selected?
Yes, it was selected in December 2029.
Okay. So sticking with that same, sticking with that same model run, that same sensitivity, 8.5, would you agree, what is your understanding of how much solar was selected under the 8.5 sensitivity?
My understanding is that no solar was selected in any year, 2027, 2028, or 2029.
Okay. In the 8.2, 8.3, and 8.4 sensitivity runs, are you aware whether or not solar was selected in 2027 or 2028 or 29 or any other years?
Yes, it appears that a significant amount of solar was selected in those model runs in those 3 years, and so that contrasts with the model run 8.5, which selected no solar.
Okay. The fact that the model run 8.5 had no solar, despite the fact that the sensitivities were combined, the combination of 8.2, 8.3, and 8.4 were combined to create 8.5. Was the selection of no solar during those years consistent with what you would expect given those parameters?
No, frankly, I was surprised to see that. I would have expected to see at least some solar selected under 8.5, consistent with the 3 prior model runs.
All right. Do you have anything else to add at this time?
I do not.
Okay. The witness is available for cross.
All right, let's have cross, starting with the applicant.
Thank you, Your Honor. Good afternoon, Mr. Burgess. My
Good
name is
afternoon.
James Goldschmidt. I am one of the attorneys representing Wisconsin Electric Power Company. I have just a few questions for you on your testimony today, starting with the answers that you just gave to your fellow witness, Mr. Singletary. In terms of the modeling that you've just described and the answers you gave about when certain facilities were selected or what types of facilities were selected, would you agree that rather than taking your word for it or Mr. Gerlikowski's, the commission can simply review the modeling for itself and let the modeling speak for itself?
Yes, though I think it was important to highlight here just because it was such a late filed, piece of information, and I wouldn't expect that all parties would have had a chance to review that.
Okay. You didn't do any of your own Plexus modeling in this case, right?
I did not.
Have you ever used Plexus modeling yourself?
I've not used Plexos, but I've used other types of modeling software that are similar to Plexos and use the same kind of underlying optimization principles.
You've never been employed by a large public utility, correct?
No, although I have had them as clients.
So you've never done in-house resource planning for a public utility that has an obligation to serve all customer loads?
No.
Are you a commodities trader?
I'm not a commodities trader.
Any experience with commodities trading?
Not directly, though I've done plenty of analysis for clients that do commodities trading on commodities.
Have you ever had experience specific to commodities trading for lithium carbonate?
No, I haven't, but I do hear about lithium commodities from clients, including battery storage developers and trade associations.
You hear about it. Okay. At page 6, line 21 of your rebuttal testimony, if we could go there, Your Honor.
And give me the page number one more time.
Of course, page 6, line 21. You state that the commission may be able to require WEPCO to allow large load customers to contribute more funding to focus on energy than the standard amount. Do you see that?
Mm-hmm.
What do you
In
mean
words,
by
please.
that?
If you could answer in words, please, sir.
Oh, yes, I see that.
Yes. Sorry, Counsel.
No, good interruption. Thank you. What do you mean by that?
What I mean by that is, my understanding is that there's a standard contribution most customers make to energy efficiency programs in Wisconsin, to the Focus on Energy program. What I'm suggesting is it may be possible for certain customers to contribute more than the standard amount as a means to procure more energy efficiency resources on a voluntary basis.
A voluntary basis for those customers, but you specifically indicate that the commission should require WEPCO to allow that. Do you see that?
Right. By allow, I mean, it would still be voluntary on the customer's part, but WEPCO would be offering that opportunity for them to do so.
And the commission would be requiring Wisconsin Electric to do that?
To make that option available, yes.
Okay. Do you know whether the commission has the legal authority to do that?
I do not, but I would hope that they do.
If you're proposing it, I would hope so too. You agree on the topic of new load, and this refers to your surrebuttal testimony at page 7.
You can go ahead. I'm having trouble.
Okay. So I'll ask the question. You can take a look if you like. You agree that new customers continue to develop energy intensive projects in Southeast Wisconsin, right?
What do you mean by continue to develop?
Well, let me point you to line 15 of your testimony where you say, I'm well aware of the unique situation the company and the broader industry are facing regarding the rapid growth of data center energy needs, which may differ from recent history. Do you see that?
Yes, I do.
So my question to you based on that is, you agree that new customers continue to develop energy intensive projects in Southeast Wisconsin, right?
Yes, I'm aware that there's been development of data center projects in Southeast Wisconsin, although none in operation to date under a energy service agreement.
Are you aware that Wisconsin Electric has an obligation to serve all customer load?
That sounds right.
So you agree that Wisconsin Electric has an obligation to serve these new energy intensive projects as they come online, as well as its current customers, correct?
Yeah, to the extent these projects do come to fruition, then they would have that obligation.
Turning now to your direct testimony on the topic of customer cost protections. At page 15 of your direct testimony, you stated, until there is an executed contract or contracts to serve new load that includes a clearly defined ramp-up schedule any new generation additions approved to serve that new load will be a risk borne entirely by existing customers. You see that?
Yes.
And you acknowledge that Wisconsin Electric and Microsoft now have an executed agreement in place as of March 22nd, 2024, correct?
Yes, I learned of that information from the company's rebuttal testimony. Although I'll note that agreement, is a sort of a partial in terms of, it's not exactly consistent with what I've stated here in terms of a signed energy services agreement.
Right. So despite the executed contract you initially said would make load more certain, in your rebuttal testimony, you state the executed contract is not enough, right?
Well, it doesn't provide complete certainty in terms of what that, load ramp up schedule would be, or, whether or not an energy service agreement will be signed.
Thank you. You just referred to complete certainty. Is it your position that the commission should not approve this project without that complete certainty?
Well, I think that the commission should consider the fact that there is still a risk to existing customers if the project moves forward until that energy service agreement is signed.
I'm just trying to get a sense of your bottom line position. Let's say we don't have that complete certainty. Is it your position that the commission should deny the application?
I think that could be, well, I think there could be a range of potential options the commission could choose or explore. One would be denying it, but perhaps that's not the best course. It could include, attaching certain conditions to the approval, or attempting to time the approval, such that we have more certainty. So there could be a range of options.
So is it your testimony that as you sit here today, you just don't know whether the commission should approve the application without the complete certainty you referenced?
I think it may be premature without some additional information, which my understanding based on, well, I'm trying to remember if I don't want to bear into confidential information here, but there was some discussion about timing that I think we had in a confidential session, and that kind of factors into what I would perhaps recommend at this point.
Okay, well, I don't mean to belabor the point. We're just about to write briefs. So my question for you, Mr. Burgess, is whether you, based on your review of the testimony, are for or against the commission approving this application based on the information we have right now.
I don't think the commission should approve the project until there's more certainty in place. And I think that's achievable.
Okay, that kind of certainty that we're talking about has never been a requirement of a CPCN in Wisconsin, has it?
I don't know what exact standards there are for, CPCN approval, but I think that it's important that, one of the considerations would be, risk to existing customers.
Okay, so as you sit here today, you just don't know one way or the other whether the Wisconsin Commission requires the level of certainty you're discussing in order to approve a CPCN.
I mean, as far, are you asking my legal opinion on this?
I'm asking what you know.
Could you repeat the question?
Let's have it read back. Read it back.
Question, so as you sit here today, you just don't know one way or the other whether the Wisconsin Commission requires the level of certainty you're discussing in order to approve a CPCN?
I guess I don't know what the legal requirements are or standards for that decision to be made in Wisconsin, but I think it's just a general matter. There, are certain considerations that I would hope the commission would take into account as they make a decision.
Okay, that's fair. Thank you. We have your direct testimony up still. Why don't we go to page 28, please, Your Honor?
Sure.
Your testimony here states that Wisconsin Electric should have used EIA's 2023 annual energy outlook instead of relying on its own cost data for the Paris BESS project. Do you see that?
Yeah, I see that.
However, here on page 28, you state that Wisconsin Electric should rely on data from programs being implemented by utilities today instead of national statistics, correct?
Yeah, but I think there's a little difference in kind here that, isn't it wouldn't be appropriate to sort of equate these.
Okay, well, EIA's data is national data, correct?
It is.
And you'd agree that the data Wisconsin Electric used from the Paris BESS project is Wisconsin specific, right?
It's yes, and it was, an outlier in terms of the, the data the company used generally for its cost assumptions, because the other, many of the other resources used assumptions based on EIA. So for consistency's sake, you would expect that would be the case for batteries. The company essentially, cherry-picked a project from a recent point in time when battery costs were higher than usual. And, in the other instance, the national data being referenced was for a resource type that actually was not consistent with what the company was evaluating. So it was looking at demand response instead of energy efficiency. So there's a little bit of, I think, picking and choosing going on here in terms of what data is being used.
With respect to using recent local projects for purposes of pricing BESS, are you aware that staff in rebuttal testimony has agreed with the company's approach?
Maybe they did, although I wouldn't necessarily agree with staff's approach. And I addressed some of this in my rebuttal testimony, pointing out the fact that, in fact, one of the company's even more recent projects was significantly lower in cost than the Paris battery project.
Are you familiar with the term MISO?
Yes.
Okay. Does MISO have any operational BESS on its system?
Yes, it does.
And how much BESS is under construction?
I don't have a number off the top of my head.
At page 36 of your direct testimony, line 4, you state, it appears that WEPCO's approach was to pre-select the company's desired resource option and then use its planning analysis to justify this decision after the fact. Do you see that?
Mm-hmm.
Do you have any evidence that the company actually did this?
Well, I think that the fact that there was no real sort of competitive process to sort of identify least cost resource and, leading up to the agreement the company made with the customer, there wasn't a clear indication that they had done a robust analysis, with some of the projects under consideration. So that's what I suspect, and I think that the company's has a burden of proof to show otherwise.
Okay, that's what you suspect, and that's your interpretation of the modeling you reviewed, right?
Yes.
You have no direct evidence that that's what the company did.
I guess I don't.
At page 10 of your rebuttal testimony, line 16. We don't need to get into the confidential part here. I'm just going to summarize at a high level. You express a general concern that Wisconsin Electric is committing new resources to new customers outside the commission's purview, correct?
Correct.
Do you agree that the commission still needs to review and approve any such projects before they can be built?
Yeah, I think that's what this proceeding is all about, right?
And that's what we're doing here, right?
Mm-hmm.
Okay. Would you agree that the company in planning and negotiations with large customers would take that regulatory backdrop into account?
Yes, although I think, more to the point here, I think, what I'm saying is, I'm concerned that there's a practice where by entering to these types of contracts, there's sort of making it a fait accompli before, it even comes to, proceeding like this, and whether or not there was any sort of consideration of, what the actual capacity need was, or like I say here, capacity need, what the viable alternatives might have been, what this might mean for the public interest. So this is all being done, and then it comes to the commission, but it's sort of presented as a pre-existing commitment, before some of these steps have been taken.
Well, is it your position that the company should be seeking the commission's approval before talking to new customers?
No, but I think that there, ideally would be at least some form of a, and this kind of gets to some of the other points of my testimony. There's no IRP process in Wisconsin, right? So there's no sort of public venue to kind of consider what some of these issues are around, what the actual capacity need is under different kind of load scenarios, prior to, specific projects being identified. And so I think that would be well worth the interest of customers and the public at large to have that kind of process in effect.
All right, but if the projects and the tariffs and the contracts are all coming before the commission for approval, then ultimately none of this is outside the commission's purview, is it?
Which contracts are coming before the commission for approval?
The contracts that the witness referred to, the contracts with large customers.
The developing contract?
I only mean whichever contracts the witness meant.
Well, I mean, there's a contract that was provided, in the company's rebuttal testimony. It wasn't part of the application. So I mean, I guess, I don't know, I guess that's being presented later in the process. Like ultimately it's coming to the commission, but wasn't clear to me at the outset of this process that, that was there. And I think it makes it more challenging to evaluate, these kind of proposals.
Okay, and that's a comment about how the commission evaluates the information it receives, not about the commission not having oversight, correct?
I suppose.
Okay. Have you undertaken any analysis to determine what would happen to the costs of this proposed project if it is delayed?
Could you repeat the question?
Have you undertaken any analysis to determine what would happen to the costs of this proposed project if it is delayed?
I haven't undertaken any analysis on that. I'm not aware that if the company has either.
All right, how about Bess? Do you understand that if the commission denies the application in this case, the company can't just go out and build or procure Bess, right? In other words, it has to start the approval process over again, right?
I guess
perhaps it might be better if you could clarify what you mean by procure this, because there's different options in how a company might secure that capacity.
Sure. My understanding, correct me if I'm wrong, is that one of your recommendations in this proceeding is that an equivalent or greater amount of BESS would be a better alternative to the Paris Rice project. Do I have that part right?
Yes.
Okay. So my question is, do you understand that if the commission denies this application, the company can't just go out and pursue that alternative without also seeking commission approval?
Okay.
Do you share that understanding?
Right. I mean, I think, I guess I'm not sure what, I mean, it's the question suggests that, there's a problem with that. I think that, the commission certainly could and has approved BESS projects before. I mean, in terms of the timing, you could, generally, BESS facilities have a very fast development cycle, 1 to 2 years. And so I think that, and I don't know to what extent there might even be opportunities to modify, existing applications to accommodate that. But I think that it's not, doesn't seem like it's outside the realm of possibility.
So let's break that answer down. You identified a certain amount of time to get the facility built, and then there's a certain amount of time for regulatory approval before that, right?
Yeah.
And my only question on this, and it's actually my last one, is have you undertaken any analysis of whether the company could feasibly get through that regulatory process and complete construction of a BESS facility in time to meet the identified capacity?
I've reviewed, based on other, a broad range of utility planning documents, the time frame for which projects like BESS can be developed. Now, that may not speak to the specific approval process involved, but I think that, and I haven't done that specific analysis. What I would add, though, is that, this maybe does also speak to, prudency considerations for, this specific project in terms of, was a BESS alternative evaluated at the time this project was being contemplated? So that's something else to be considered here.
Okay, just to make sure I have a clear answer to my question, you have not undertaken the analysis that I asked about, correct?
Correct.
Okay, thank you. I have nothing else for this witness.
Okay, is there other parties wish to cross? No, how about redirect?
Redirect, Your Honor. Mr. Burgess, Attorney Goldschmidt asked you some questions and you had a discussion about contracts. Do you recall that?
Yes.
And during that discussion, you brought up elements of timing, and you brought up elements of ramp rate. Do you recall that?
Mhm.
Okay. Were you present earlier today when WEPCO witness Stasek was testifying?
Yes, I was.
Okay. And do you recall the discussion there about the tariffs related to the very large data center customer in Southeast Wisconsin, and the fact that those are forthcoming and get to some of the issues related to this case? Do you recall that conversation?
Yes.
Okay. In this instance, we're talking about two, in Wisconsin, we refer to them as we use the term tariff, and I'm presuming that what the company is will be applying for approval would be consistent with that language. I'm just going to go based on that. But that discussion you had earlier about ramp rates, about timing, would those be the kinds of things that you would expect would appear in what you understand those very large customer tariffs will represent? Like those terms would be the types of things that could be included in those types of agreements or tariffs?
I'm going to object to leading, Your Honor.
Well, all right.
What I'm trying to get at is whether or not, Mr. Burgess, he uses in his particular terms of art contract. And the company has been, largely talking about these very large customer tariffs. And what I'm trying to establish is whether or not to Mr. Burgess's understanding that they would be functionally equivalent in this case.
Mm-hmm.
Right. I mean, I think maybe there's some distinction there in terms of, the tariff laying out the basic parameters to, that would underpin a subsequent energy service agreement or contract. But, I guess, yeah, there's sort of, I would, in some respect, equate those.
Okay. So you had testified earlier when you were discussing this with Attorney Goldschmidt that part of your concern was that those contracts don't exist right now. So essentially those parameters don't exist. Is that an accurate representation of what you're talking about? Okay. So to the timing element we were discussing earlier, if those large customer tariffs existed today, would that help to alleviate some of your concerns about the parameters related to load in Southeast Wisconsin?
Yeah, I think it would go a long way.
Okay. Attorney Goldschmidt asked you some questions related to alternatives to the Paris project, specifically BESS. Do you recall that?
Sorry, could you repeat that?
Sorry. Attorney Goldschmidt asked you some questions related to the question of timing if the commission were to deny this project and the company were to instead, as you suggest, pursue BESS resources. Do you recall that?
Right.
Okay. And in that cross-examination, he asked you whether or not you had done an analysis of the cost impacts of putting in place a BESS resource in time to meet the projected load. Do you recall a discussion, specifically his use of in time? Do you recall that?
Yes, and maybe I'd just add to that I think part of the premise of his question was an assumption that a resource would be needed at a certain point in time, although I don't think that has necessarily been adequately demonstrated here in terms of, could the company add a BESS resource, perhaps in 2028 or 2029 and still meet its resource adequacy obligations while serving the new customer load versus, say, a RICE unit in 2026 or 27. So I think, and again, some of this more recent modeling is showing that, you know, the RICE unit may not be needed at all, or might not be needed until 2029, which would give much more time for that kind of delayed approval to occur.
Okay. Is it your understanding that this issue of resources being in place in time to meet load is largely tied to you know, this large new data center load in Southeast Wisconsin to Microsoft?
Right.
Okay. And therefore it's tied to the projections about when that load would be placed on the system. Is that your understanding?
Objection, Your Honor. I let it go once, but this is more leading. And it should be in confidential session if we're going to get into detail.
I agree with that. Okay, well, I can let the why don't we ask another question in a different way?
Sure.
I think it might solve our problems all
Sure.
around.
Sure. I'll get to the next question, which I didn't think got to any confidential specifics.
Right.
With respect to
just to let you know, I mean, I don't know where the line is at this point anymore because the name of the company has been in public and in confidential, and so but yeah, if you could rephrase, I think that would
okay. So with respect to the large new load that the company is trying to place resources in on time to meet, what is your understanding of who has determined the timing of when that new load will be placed into service and connected to the utility?
My understanding is that the company's received information various points in time about a projected load from, you know, prospective customer, and that there was, you know, sort of an initial projection, you know, back in early 2024, and now there's an updated projection that came in sort of fall of that year. And so that's sort of, those are, we're serving as inputs to the overall load forecast the company's using in its resource planning.
So the timing and the magnitude of those loads, am I hearing that it's your understanding that those are based off of representations by the customers that would be bringing that new load? Okay.
Yeah, exactly. And
okay.
You know, and I don't know to what extent the company has sort of input to that as well, but I think largely they're receiving that information from the customer.
Okay. That's all I have.
So I just wanted to ask a clarifying question for you, Attorney Burgess. You're not an attorney, is that correct?
I'm not an attorney.
Okay, I was just looking at your resume and your background. It didn't look like that came up. Just wanted to just make sure it wasn't missed somewhere. And just wanted to make sure I understand that you've never practiced or had involvement with a CPCN proceeding in Wisconsin before?
No.
No, okay. Just want to make sure we understood that. Okay, so that's any redirect on those questions?
I do not, but thank you for asking.
No, I'm asking Cub for redirect. No, okay, all right.
Oh,
good.
on those questions. Okay.
Yes, all right.
No,
Thanks.
Your Honor.
Yeah, I'm not inviting further rounds of cross if I can avoid it. All right, thanks. You're excused.
All right. Cub calls Dr. Steve Keim.
So just off the record, Debbie, you're doing okay?
Yeah, just
All right,
stretching.
just checking. How's
Thank
your
you.
dog? Dog giving you trouble? Or no?
Now that I've spoken, she'll
Shouldn't
probably
I? Yeah,
be in
right.
here.
Don't open that box. Yeah. All right. So let me just adjust some. Looks like, well, I don't know. Maybe I'll just unpin you for now. All right. Where's Dr. Keim? Here you are. Great. Let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Good afternoon, Dr. Keim.
Good afternoon.
Did you prepare cause to be filed direct and surrebuttal testimony in this proceeding?
Yes, I did.
And if asked the same questions set forth in your testimony today here under oath, would your answers be the same?
Yes, but I noted you didn't ask me what my name was or to spell it.
Apologies. You've been around so long. Could you state and spell your name for the record?
Yes. Steve Keim, Stevekihm. Thank you.
Thank you for catching that. Is your testimony, would your answers be the same today? I believe you said yes, but I just wanted to make sure.
Yes,
Okay.
Yes.
Okay. All right. Do you have any corrections or anything to add here
I do
today?
not.
Okay. The witness is available for cross.
Okay. Start with the applicant. Any questions?
Just two questions, hopefully.
I'm sorry, who's speaking?
Joe Wilson.
Thank you. Oh, I didn't see your backside up.
Hi. Good afternoon, Dr. Keim.
Good afternoon, Mr. Wilson.
Your Honor, could you pull up the cross exhibit we sent over, which is Dr. Keim's testimony from the Weston Rice case?
Yes. I think that's it here.
And specifically, want to look at page 5, please. Dr. Keim, there's no real elegant way to do this, so I'm just going to read a bit of your testimony from the Weston Rice case, okay?
Fine.
In line 11, you testified that if the exercise is to be useful in a real-world setting, the boundaries of a forecast analysis must push the limits of plausibility. Then I have a quotation from a publication by Sappho. The quotation is, "A good boundary is one made up of elements lying on the ragged edge of plausibility. There are outcomes that might conceivably happen, but make one uncomfortable even to contemplate." End quote.
I'm sorry, even to
Contemplate.
Thank you.
End quote. The world is much more complicated and the future is far less certain than we would like to believe. If we are to analyze the potential cost effectiveness of the Rice units, feeling comfortable with the analysis cannot be the goal. When making a resource choice, we want to consider the implications of operating over a range that includes both likely scenarios as well as those at the limits of what could happen, which should include scenarios that may involve fundamental changes in what we have grown accustomed to, and not only where the assumptions seem to be the most likely. Have I read that correctly?
I believe you have.
Okay. On the next page, Your Honor, page 6, beginning on line 10, you testified that we must fight against that powerful urge if we are to wish to conduct an analysis that is useful, even though in so doing we may seem to be applying assumptions outside the bounds of reasonableness. In most cases, those bounds will turn out to be substantially different from where we are today. A good forecaster knows that and then proceeds in a consistent manner. A poor forecaster pretends that the future is more certain than we know it is. Have I read that correctly?
Yes, you have.
You still believe and stand by the opinions you expressed about modeling in the sworn testimony I just read, don't you?
Yes, I just want to make one thing clear. This is about analysis. How you make a decision is different, but
well, your testimony there was clearly about analysis and modeling, so I think that's clear.
Yes, that's what it's about. I just want to make sure there wasn't confusion about that.
No further questions.
All right. Cross from any other party or staff. When I say party, I mean and staff. Sorry. And any redirect. No, not hearing anything. All right. Thanks. You're excused.
Thank you.
All right. And Your Honor, Dr. Keim and I are going to do a little roll swappity do.
Oh
and
boy, this is
we'll
going to be
proceed.
fun.
So
Let's see how good you do.
so we're still on the record, Your Honor.
As far as I know.
Okay. The Citizens Utility Board calls Corey Singletary, please.
All right. See you there. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, go ahead.
Please state your name and spell it for the record.
Corey Singletary, Corey Singletary.
And did you file in this proceeding direct, rebuttal, and surrebuttal testimony?
I did.
And you also filed several exhibits. I don't remember the number off the top of my head.
I caused to be filed 2 exhibits in this proceeding.
Okay. All right, thank you. And if I asked you a question set forth in your testimony today, would your answers be the same as written?
Yes.
Okay. Mr. Singletary is available for cross.
Okay. Applicant has cross, I'm assuming?
Yes, we do. Good afternoon, Mr. Singletary.
Good afternoon.
You discussed the role of integrated resource plans, which I'll call IRPs, throughout your testimony, right?
Yes.
Is it fair to say that you believe IRPs should have an expanded role in utility planning in Wisconsin?
I guess in order to answer your question, I do need to distinguish between integrated resource planning insofar as the modeling exercise, right? In terms of planning for a system in an integrated, planning for resources in an integrated fashion, and the process by which an integrated resource plan is evaluated. With that clarification, I would agree to your question that yes, I believe that both should play a greater role in Wisconsin.
In your surrebuttal testimony at page 7, you want me to wait for you, Your Honor?
No, go ahead. We'll get it there. Unless you need it, Corey, do you need me to? I'll just wait. Just wait a second. That's fine. You can wait a minute.
Okay. I have it in front of me, Attorney Wilson.
There we go.
You make clear that CUB is not advocating for an IRP in this case, right?
Well, again, to be clear,
I should clarify that. You're not advocating that an IRP be conducted in this case, correct?
Well, again, to my earlier clarification, when I look at what the company has prepared through its generation reshaping plan, or GRP, to me, that is an integrated resource plan, because it has sort of the hallmarks of looking at all the resources for the utility in an integrated fashion. And when the company did the modeling for the GRP, it allowed several, if not many, if not all, or close to all of the resources to be selected kind of as a whole, right? So an IRP exists in this proceeding. I guess to your question as to, we are not arguing that we kind of go back and do a holistic IRP review process for the entire utility with respect to where we sit in this proceeding. Does that distinction make sense?
It does, and I'll try to use the term holistic IRP to catch that second conception of IRP that you've expressed. Okay.
Sure.
Are you arguing that the commission should condition approval in this docket of the Paris Rice Station on having the company prepare a holistic IRP at some point in the future?
That would certainly be my preferred outcome, but I don't believe that the CUB witnesses' testimony, including mine, is that in order to consider this facility, the Paris Rice facility, that we have to kind of stop and pause this and go back and do that review. But if your question is whether I would agree with a condition from the commission that on a going forward basis that the company's IRP in the form of the generation or shaping plan or whatever it might be called in the future should be reviewed holistically and separately from a specific facility application, then yes.
Would you advocate having the holistic, separate IRP that you're discussing apply to any currently pending applications?
Again, my preference would be yes, but we recognize that there are certain practical realities with respect to timing that would likely make that infeasible in this situation. Again, depending on, and this gets to a little bit of witness Burgess's testimony and some other witness testimony, depending on one's view about the load forecast and timing and when certain resources are needed. But I guess the answer is no, it would not. It's not that we're not throwing a flag on the plane saying we need to stop everything.
Thank you. And I think you just restated your position that the Generation Reshaping Plan, or GRP, is an IRP, right?
Yes, it is an exercise. It is a resource plan developed in a way that is consistent with what I would call an IRP. There is still, like I think I put in my rebuttal testimony, whether or not one views it as a well-developed IRP is separate. But yes, it's an IRP.
And I think in your rebuttal testimony at page 4, you cited a provision of the U.S. Code that defines IRPs and said that you think that the GRP is consistent with this definition, right?
Yes, I use that definition to try to avoid disputes about source. But yes, in general terms, I would agree that it, again, conforms with the general conceptions of what an IRP is.
You critique the structure under current Wisconsin law, which requires consideration of individual projects one by one, as opposed to through a comprehensive or holistic IRP, right?
I critique the fact that Wisconsin law requires an evaluation of individual applications one by one, combined with a view that the commission cannot review the integrated resource plans that the utilities are preparing outside of those individual CPCN or CEA applications. That's an important distinction I want to make.
You'd agree, wouldn't you, that Wisconsin law doesn't currently require comprehensive resource planning in the way that you've suggested it should, right?
Correct.
The GRP that has been discussed extensively in this case covers more resources than just the Paris Rice project, right?
Yes.
And it's your understanding that the GRP rests on economic modeling that allows the model to pick various resources based on assumptions about the future, right?
In general terms, yes, the model's ability to pick resources is dependent upon inputs and how the modeling is conducted. But again, at a high level, yes, I would agree.
Is it your understanding that the GRP includes multiple scenarios and sensitivities that alter the input assumptions?
Yes.
You've had quite opportunities to ask questions about the GRP and discovery in this case, right?
Yes.
In your rebuttal at page 6, line 19, you note that you would prefer a process under which the commission would consider a, quote, integrated comprehensive, end quote, IRP process, which you contend would then lead to, quote, simplified litigation and likely quicker decisions, end quote, on individual projects, right?
I'm sorry, what page was that on?
Page 6.
I think. Okay.
Line 19.
Yes. That would be fair.
Would you agree that facts or circumstances might change in ways that could render decisions reached in a broad IRP process outdated or no longer valid?
I would hesitate to use the term the phrase no longer valid, but certainly in any IRP process, things will change after, the initial modeling is done. Yes.
You advocate an IRP process every 2 to 3 years, right? That's at
Yes.
line or page
Yes.
9. Yep.
Mm-hmm.
But would you agree that the demands for new generation being placed on Wisconsin Electric from, for example, data centers are changing much more rapidly than every 2 to 3 years?
I would agree that over the last 2 to 3 years, that situation has changed quite a bit. Whether or not that will continue to be as dynamic going forward every 2 to 3 years, I don't know. I don't know if anyone knows.
Are you aware that the historic advanced plans used to take weeks or even months of just hearings to litigate?
What you said is consistent with the war stories I've heard from former commission colleagues. Yes.
Would you agree that if the legislature wanted the commission to conduct IRPs, it could pass legislation requiring the commission to do that?
Yes.
And are you aware that a form of IRP was included in each of the last 2 budgets that Governor Evers proposed but did not make it through the legislature?
That sounds correct, but my understanding of the budget process is policy items like IRPs typically get stripped out of budgets.
Is it fair to say that one of your significant concerns in this case is that the company has presented information about the Paris Rice project specifically without enough consideration of how that project would fit into a larger IRP?
Yes, with the addition that in the way that it fits in with the larger IRP is it limits the ability to contemplate what a different portfolio would look like if one or more facilities were altered or substituted.
Okay, so I think that's a yes to my question, right?
Sure, we can call that a yes.
Judge Newmark, could we pull up the cross exhibit that was Mr. Singletary's testimony in the Weston Rice case, please?
I think we have it here.
And specifically page 7. As I did with Dr. Keim, I'm just going to read a couple of excerpts from this and ask you to follow along and confirm that I'm reading it correctly, okay?
Okay.
So beginning on line 14, you say, and this is a critique of
it would be helpful if you just read the question and then the answer as well.
Sure.
Yeah, thanks.
Just to set the context, and you can disagree with me if I'm wrong, I think this is a critique of how the Wisconsin Electric did modeling of in support of the Weston Rice case. Is that fair context for what we're looking at here?
It probably is. It's been a while since I've read through this entire piece of testimony.
Sure. So beginning on line 13, there's a question that says, do you have any additional comments regarding the GRP, the Generation Reshaping Plan? And you answered, as I noted previously, the entire needs analysis and economic analysis presented by applicants in support of this project takes the form of information about the GRP. A little further down at line 18, you say applicants have provided no need or economic information that considers only Weston Rice. Effectively, what applicants have done is present what many would consider to be an integrated resource plan, or IRP, as the basis for approval of a single facility within that IRP. Have I read that correctly?
Yes, you did.
Then on page 10, you can continue in a similar vein. Beginning on line 1, there's a question: how does this affect the commission's decision in this case? You say this brings me back to my procedural concerns. By limiting their need and economic analysis to the GRP, presenting no facility-specific evidence related to Weston Rice other than what commission staff asked applicants to provide, applicants are implicitly asking the commission to approve the GRP and IRP in effect in this single facility CPCN proceeding. And therein lies my concern. This is not an IRP proceeding. The issue in question before the commission in this proceeding is aimed at the proposed Weston Rice facility, not at assessing reasonableness of the GRP as an IRP. And yet, based on the record evidence to date, applicants have placed the commission in a position where, if it were to approve the Weston Rice project, its approval would rest entirely, if not at least substantially, on the merits of the GRP from a need and economic impact standpoint. Have I read that correctly?
It appears you have.
So in the Weston Rice docket, your criticism appears to me to be exactly the opposite of your criticism in this docket. And in other words, you were arguing in Weston Rice that the company was discussing the GRP too much, and now you're concerned that the company is discussing the GRP too little. Is that fair?
No.
Why not?
Because in pulling out these portions from my direct testimony, you're missing some broader context. This facility, the Weston Rice facility, was one of, might have been the first, I don't recall exactly, but it was one of the first projects that was taken up by the commission under the GRP, the first time the GRP appeared before this commission. And a concern that Cub had, that I had at the time, was, as I stated in my testimony in part, is the way that it was being presented was there was a concern at that time, again, context specific, that an approval in this one facility could serve as a backdoor to essentially pointing back and saying the commission approved this facility, and and under the GRP, and therefore everything within the GRP as set forth right now is either implicitly approved, or a decision in the Weston Rice proceeding would carry some additional weight as precedent for the commission as it reviewed the other concurrently applied for projects for the initial GRP at that time. And so within that specific point in time in history, the concern was, okay, well, we've always done it a certain way. We would prefer an IRP process consistent with the decision I made
I'm sorry.
Hang
I'm
on,
sorry.
your audio is breaking up.
I thought it was just me.
Sorry,
No,
where did you lose me?
We would prefer.
So let me-
we've always done
and-
it a certain way. We would prefer.
I can interject before you answer.
We would always.
It may be useful if you tried taking out. Looks like you're blurring your background, and because of that, it's maybe taking up some resources on your computer. Okay.
Just trying to
see if that helps. Okay.
All right. So historically, the way that CPCNs had been reviewed was based off of evidence that was more utility specific. We had always sort of done it. I'll characterize it a certain way, and IRPs, at least in the way that the GRP is constructed, and some other analyses by other utilities more recently, was not the substantial evidence, my understanding, substantial evidence that those proceedings were based off of. And so from my perspective and from Cub's perspective at this time, this represented a switch in paradigm, and there were concerns about what that would mean with respect to precedent and for not only this this case, this facility, the Weston Rice facility, but other facilities, which if I recall correctly, included some solar, some BESS, and a combined cycle gas plant, and a bunch of other things. So that is the context in which this testimony is rooted.
So two things. Am I correct to summarize that you do not share the same concerns now about the role of the GRP that you had then?
Given that using IRP-like portfolio analysis seems to have been accepted by Wisconsin utilities as more of a best practice, then yes, my thinking has changed a little bit with respect to the specific points of concern. Yes.
Would you agree that presenting a project in the way that Wisconsin Electric has in this case, in other words, talking about the broader context of the GRP in the context of a CPCN proceeding is an improvement over the historic way of litigating CPCNs that focused exclusively on single projects?
I would agree that it is an improvement. Yes.
Mr. Singletary, you have undergraduate degrees in biology and international studies, right?
Correct.
You have a master's in international public affairs, right?
And a graduate certificate in energy policy and analysis. Yes.
You've gotten training in various aspects of utility regulation, and you worked at the commission for quite a while, right?
Yes.
Have you ever yourself negotiated a engineering procurement and construction contract, or EPC contract?
No.
Have you, did you have any training or classes you took in college or graduate school that involved negotiation of EPC contracts?
Negotiation? No.
Have you previously provided testimony about the specific terms of an EPC contract?
I would have to do, I may have when I was on commission staff. I was assigned the task by the division administrator in the energy division to evaluate the engineering procurement and construction agreement, as well as the maintenance agreement for the then Fox Energy Center 3 project, if I remember correctly.
You've read.
Yep.
I'm sorry.
So I've in the course of my work on construction litigation, I have had the responsibility of reviewing and critiquing these types of documents. Yes.
You read the EPC contract that's at issue in this case, right?
Yes.
And I assume you read the Fox 3 EPC contract?
I'm sorry, I assume you read the
Fox 3 EPC contract?
Yes. And also, I don't remember, to your question was about testifying. I don't remember if I testified to it, but I also reviewed the EPC and maintenance agreements for, I believe it was the Badger Hollow facility, as well as and possibly the Two Creeks solar facility.
Okay. So you've named 4 EPC agreements that you have reviewed. Other than those, do you specifically recall reading any other EPC agreements in your life?
I don't recall, but that doesn't mean I haven't.
Do you claim to know what standard terms and conditions are for EPC agreements in the context of construction of power plants?
No.
I want to talk a little bit about reliability as the last topic. Did you read Mr. Arndt's rebuttal testimony in this case?
I did, but I would have to refer to it.
Your Honor, could you please bring up page 10 of Mr. Arndt's rebuttal?
Sure.
Thank you.
There we go.
Thank you. Mr. Singletary, beginning on page 10 and continuing through page 15, Mr. Arndt discusses reliability concerns expressed by the North American Electric Reliability Corporation, or NERC, Reliability First, and MISO. Do you recall that testimony?
In general terms, yes.
What is NERC?
The North American Electric Reliability Corporation.
What do they do?
They are charged by the Federal Energy Regulatory Commission with overseeing activities related to reliability across various regions in the United States, including reviewing standards and information. I believe Clean Wisconsin's witness actually gave a more articulate answer than I did, which I would agree with. But
Do
that's
you
the general
understand
understanding.
NERC to be a nonprofit?
Yes, I do.
Is NERC a credible source on the issue of grid reliability?
NERC is a credible source, yes.
And what is reliability first, to your understanding?
I don't recall off the top of my head.
Subject to check, would you accept that it's the regional organization for the reliability and security of the electric grid under delegated authority from NERC?
Well, we can accept that for now, yes.
Do you consider reliability first to be a credible source on the issue of grid reliability?
Like I said, I don't have information about reliability first stored away in my memory in an encyclopedic fashion. So it's related, it's related to NERC. So I have no reason to argue that it is not a credible source.
You don't have any information that would lead you to think that reliability first is biased in any way, do you?
I have no information like that, no.
Do you consider MISO to be a credible source on issues of grid reliability?
Again, MISO is a reliable source, a credible source. Sorry, switching up words. A credible source.
On pages 10 through 15, Mr. Arndt is talking about grid reliability and these various organizations' positions on grid reliability. Do you have any basis to dispute Mr. Arndt's description contained on these pages?
No.
On page 13, Mr. Arndt talks specifically about NERC's view of the importance of natural gas generators to grid reliability. Do you have any basis to dispute his description contained at lines 6 through 13?
I have no reason to dispute the statement that natural gas fire resources are a vital grid resource, but I would caution against drawing the conclusion that that means that natural gas generators are the only type of resource that should be considered as vital.
Is CUB opposed to approval of the Paris Rice project?
With the evidence that's in the record right now, yes, CUB is opposed to approval of the project as proposed based off of the information that we have and the testimony consistent with the testimony that we've provided.
Thank you. Nothing further.
Okay.
Your Honor, I have some redirect if there's no more cross.
Hang on just a sec. So I'm hearing, let's go off the record. So I think it's on your mic, Steve, that I'm hearing a buzz.
Oh, well.
It sounds like a
Sounds like a little fan.
Yeah.
Oh, I'm in a quiet room here, so
Huh.
I'm not.
Well,
I can try moving to a different room. I'm in.
Well, let me just try muting your mic. Yeah. So it's definitely from your. But in the meantime, let me just ask if there are any other parties that wish to cross. No. Yeah, that's an odd sound coming since you can't really hear it yourself.
Oh, you know, it might be, hold on, I have a internal heating system. Okay, I just turned that off. Did that help, or are you still hearing something?
No, I'm still hearing it.
I think it's actually the fan in your laptop. So
Oh.
how you're holding it right now makes it less loud. So maybe whatever
You
you're
just
doing.
stand there and
Anything to accommodate the commission. Okay.
Yes, there you go. You're
You
used
can
to
hear
that.
me? So was there any other cross, Your Honor?
No, there's no other cross.
Okay.
All right, back.
Let's yeah, I think that's a little bit better, so that'll be helpful. Yeah, let's get back on the record. So you had some redirect, Agent Keim.
Yes, Your Honor. So, Mr. Singletary, Mr. Wilson was talking about one of the characteristics of the advanced plan was that the hearings, just the hearings, took 13 weeks. Do you have any comment on that?
Yes, I would say that like a lot of things before the commission, it is case and fact specific. You know, I wasn't there. I wasn't at the commission, but the advanced plan was, you know, the way the advanced plan was to be conducted was specified in some detail, more detail than is often common procedurally for specific commission reviews in statute. And what I would offer is that it is highly probable that the way that the advanced plan unfolded from a procedural and scheduling and timing standpoint was likely a product of the specific construction of the advanced plan and how the commission at the time interpreted its charge under the advanced plan statute and how it carried out that review. So it is not, you know, to say that the advanced plan took a long time is not to say that any IRP review process will take a similar amount of time.
Okay, that was going to be my next question, so thank you for anticipating that. I just have one more. You have noted that we really do have an integrated resource plan in the sense that the grid reshaping plan is a form of that. Do you remember that testimony that you gave?
Yes, the generation reshaping plan, yes.
Oh, I'm sorry, generation. How would a commission-sponsored, how might a commission-sponsored IRP differ from the GRP? And would there be other things that would be involved in that?
From a modeling standpoint,
Your Honor, this goes beyond the scope of the cross.
Well, you were asked him all about the advanced plan, and you got him to say that the GRP was an IRP. I'm just trying to follow up because now we're talking about other IRPs. That was in the cross-examination.
Let's have that question read back. I don't think I followed along quite as well as I had hoped.
Question, how might a commission-sponsored IRP differ from the GRP? Would there be other things that would be involved in that?
I'll allow that. I think we kind of described the holistic aspect of IRP. So for him to, and that was part of cross. So for him to go into a little more detail on that's fine.
yeah, I think it circles back to the distinction I made with Attorney Wilson at the beginning is you ask if there would be a difference, and from a portfolio or resource plan modeling perspective, it wouldn't necessarily be the case that it would differ that much from the generation reshaping plan or how the generation reshaping plan itself was modeled and developed. The difference would be in the process and the way that the commission could consider each element within that resource plan, in that portfolio, and how changes or modifications to inputs like load forecast or unit selection would affect other facilities, as well as timing and amount of capacity needed. And so it wouldn't change the technical aspects, but it would change the way the commission reviews and is able to exercise regulatory oversight over the utilities resource planning process and then ultimately procurement of those resources.
I have nothing further, Your Honor.
Okay, I did have a clarifying question for the witness, and it relates to the quote that's been now brought to everyone's attention for a number of witnesses here. The rebuttal, Arndt, page 13, quoting from the NERC document. When natural gas fired generators are a vital grid resource. And I have to say, like, when I see these quotes, I am going into the document if it's been, well, I guess even if it's not been provided. If it's quoted, I'm finding the document, I'm checking those quotes to make sure they're accurate. But I didn't realize that grid is a word that's substituted from the quote. And because it's been brought up and has become, more of a critical quotation for the case, I wanted to go into the document and just make sure that the witness understood what that substitution was, the word grid. So I do have that page here. And to me, it looks like what was grid substituted the acronym BPS. So the quote appears to be natural gas fired generators are a vital BPS resource. And I just wanted to ask the witness if you understood BPS and grid to be equivalent, and if you agree with that statement still.
There's, I guess, two parts to your question, Your Honor. Whether or not BPS and grid are equivalent, I will admit I am not recalling that particular utility acronym at this moment. I don't know if it's in the document.
It should be, yeah. Let's see if we can.
It means bulk power system.
Ah, okay.
Well, let me just actually find it where it's defined in the okay, yes. In the document it does. It looks like on page 3 it says North American bulk power system is then reduced to the initials BPS. So is that equivalent substitution with the word grid the way you understood that sentence to read?
Yes, typically when we use the term grid, we're talking about the bulk power system rather than, oftentimes, the bulk power system rather than the distribution level. So yes, that would be consistent with my understanding.
All right. Okay, just want to make sure we're all on the same page there. Okay, that's all I had. Any questions, Mr. Keim, about that?
No, and Cub has no more witnesses, Your Honor.
Yes. Okay, great. All right, thanks. So you're excused and we can move on. Let's just go off the record for a bit. I think we had Clean Wisconsin witnesses next. We are coming close to, and close I say in terms of cross timing, close to our hopeful deadline for today at 5 p.m. I don't really want to go too far over that time frame. So when it comes to the remaining witnesses, it does seem like we'll need to go into a second day.
So, Your Honor,
yeah,
I assume you're anticipating taking a 10-minute break or something now for Debbie's sake, or shortly.
Maybe.
Nevertheless, nevertheless, I'm fairly confident we can finish our cross well before 5 o'clock. We've got a cross for 2 more witnesses, and neither of it's very, very extensive.
Okay, so then we have staff as well. So no, there's still no questions for staff. Okay. All right. Well,
we do have questions for one staff witness, Your Honor.
Okay.
DNR witness.
The DNR witness, yes. Right, okay. Okay, I guess the question I was having, possibly we could take Kel and Holloway before a break, if there's no questions. Well, I guess Holloway had some additional statements, so don't know where that's going to end up.
That to take long, a few minutes at most. Couple minutes.
Right. But depending on what he says, we don't know where that's going to go. So,
yeah, we could do it now, Your Honor.
Yeah, so I was going to have Kel, and then we'll take a quick break. So where are you?
I'm here, Your Honor.
There you are. Okay. You're not, yeah, just pin you here. All right. Okay, great. So raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, so state your name, please.
My name is Andrew Kell.
And which party are you with?
I'm with Renew Wisconsin.
Okay, and did you file direct rebuttal and 2 exhibits?
Yes, I did.
And are those documents complete and correct to the best of your knowledge?
Yes, they are.
Did you have anything to add?
No, I do not.
Okay, so I can receive those documents. Any questions for witness Kell? No? All right, thanks. You're excused.
Thank you, Your Honor.
All right, so what do we have? 3:40. Yeah, let's take, well, it's gonna be tricky. Let's take a 10-minute break. Said I wasn't gonna go too far. Well, we may just go into the next day. I just don't want to push people too far. Let's take 15 minutes for now. So be back at be back at 5 to 4, and we'll take it from there.
Is it?
What's up?
I was gonna say, if it's really close, it's not
Yeah,
horrible.
we'll see. Yeah, it's hard to tell. I mean, it's hard to tell still.
Okay.
We'll see. Yeah.
Okay.
Okay.
Thanks.
Thanks. All right, looks like we're getting back here. So I see witness Holloway is available. Because we can go out of order to take Town of Paris if no one objects at this point. This is going to be quick. I'm not sure who's in the WEPCO attorney seat here. I know that we had some last minute additions to the service list. So if you can just let me know who you are.
Thank you, Judge. I'm Elizabeth Riccozzi on behalf of the applicant.
Okay, and just spell your last name, please.
Yes, Rakoczy.
So how does that sound? Should we take Holloway out of order?
That works for Town of Paris, Your Honor.
Yeah. How about
No
Clean
objection from us,
Wisconsin?
Your Honor.
Clean Wisconsin.
That works.
Okay.
Judge Newmark, I just found out that one of our witnesses now has a conflict that's come up tomorrow. So as long as we can get to witness Goggin today, that'd be great.
Goggin, why don't we take Goggin first then, just in case? That really is the correct order anyway. All right, so we'll do that one, and then we can switch to Town of Paris. So we have everyone seated properly here. Let me pin the right people. Goggin, can you just give me a word or two? You'll pop up on my screen.
Hi, yes, can you hear me?
Yeah, I can hear you. I should be able to do that from here. There we go. Great. All right, excellent. So are you ready to go? We got Debbie on the line. So before we get on the record, I just want to mention the reason why I'm anticipating or hoping to not to go too late has nothing to do with the court reporter. So don't get any misimpressions that she's driving any reason for going quicker or not going as long into the evening as we've been doing in the past. This is my experience, especially with the last WEPCO rate hearing. That was a 10-hour hearing in one day, and we just were not at our best by the end. So I think that for that reason and others, but I've had that experience in a number of recent cases. So I just wanted to give people a little more time to be fresh in their minds and not be bogged down just by fatigue. Another thing I wanted to say off the record is that if we did an advance plan today, it would not take 13 weeks because not if I'm the ALJ. That's irrelevant to this case, but I just wanted people to just say, don't draw dropping when they say advance plan. I've actually reviewed some of the transcripts from the old advance plans. I don't know if they're still available. They may be destroyed by now. But one thing I wanted to note for people so they don't get too scared is that at least the first few advance plans, there were 8 altogether. At least the first probably half of those didn't do written testimony prior to that time. So all direct was spoken, question and answer. So, when you look at weeks of hearings, I think just about any hearing we would do now, if we did it without written testimony, would take a much longer time. It would just destroy us. We'd shut us down. So that's another aspect of why those cases took so long. Regardless of the fact that they're huge and complicated. And the advanced plan, the envision, the setup there was every utility was involved in the one proceeding. So yeah, it was a massive undertaking. But with that, let's get back on the record and we'll start with witness Goggin. So I'll swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
Yes.
All right, let's go ahead.
Thank you, Judge Newmark. Good afternoon, Mr. Goggin. Could you please state your name for the record?
Sure, Michael Goggin.
And Mr. Goggin, are you the same Michael Goggin that prepared and caused to be filed direct and surrebuttal testimony and associated exhibits in this docket?
Yes.
To the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes.
And do you have any corrections you'd like to make to your testimony today?
No.
Thank you. One sir question for you. On pages 9 and 10 of his sir rebuttal, witness Gerlikowski critiques your claims that the long range transmission plan or LRTP lines will significantly increase WEC's access to wind energy, claiming you cite only one example, the Grain Belt Express, that doesn't run through Wisconsin, and that MISO, quote, has faced multiple day wind droughts in recent years, end quote. Do you have any response to Mr. Gerlikowski's critiques?
Yes, I did cite the Grain Belt Express example, which does interconnect into MISO, but the fundamental physical principle of diversity in wind output patterns applies everywhere. There's geographic diversity in weather and climate, and weather systems move over time, so that the output profile of any two wind plants tends to be less correlated the farther apart they are. And so what this means for the transmission delivery is that you can fit more megawatts of wind onto a transmission line than there are megawatts of transmission capacity, because they're not going to all the wind plants are not going to be at peak output at the same time. And yeah, I could have cited other examples where this has been demonstrated. The utility Pacificorp in the Western US has used similar loading ratios and putting a lot more megawatts of wind capacity onto its each megawatt of transmission expansion that it's been planning and conducting. This geographic diversity also is the how we address the wind drought issue as well. If you have a localized period where you have low wind speeds in neighboring regions or neighboring states, you often have average or even above average wind output during those periods, and that cancels out some these localized wind drought events. And certainly, given Wisconsin's location, it can access wind resources from other parts of MISO, but it also, MISO has strong electrical ties to the PJM grid, which is just south of Wisconsin, and there's a lot of wind resources there. So there's a lot of geographic diversity that helps address both of these concerns.
Thank you. The witness is available for cross, Your Honor.
Okay, so let's have questions, I believe, starting with the applicant.
Thank you, Your Honor. Mr. Goggin, just following up on that Sir rebuttal testimony. The mechanisms that you're talking about putting more wind on a given transmission line, that's a mechanism that's not currently incorporated in ISO's reliability adequacy studies. Isn't that true?
Okay, before we answer, can you just introduce yourself to the witness?
Oh, I'm sorry. Yes. Mr. Goggin, I'm attorney Patrick Proctor Brown. Good afternoon. I represent the applicant. We haven't met before today, right?
I don't believe we have.
Okay, so just following up on your short testimony there, the mechanism that you just talked about with Pacificorp and the Grain Belt Express, those are where you add more wind to a given transmission line. That is not currently a mechanism incorporated into MISO's reliability adequacy studies. Would you agree with that?
I don't know whether it's in the studies, but the mechanism would certainly be applicable in this case, because what we're talking about is adding new wind capacity into MISO, and that wind capacity is going to be enabled by the transmission expansion with the LRTP lines, and that's what I was testifying about. And what I was explaining is that there's going to be many more megawatts of wind capacity enabled by each megawatt of transmission capacity expansion. So it certainly is applicable. And in my Sir rebuttal, I did walk through what I had explained in my direct testimony about the Wisconsin import limits and how they factor into the MISO capacity auctions and how that's not a binding constraint. Really, the constraint in MISO is the ability to interconnect new wind, and the LRTP lines and this geographic diversity benefit of wind is the really relevant factor there. So that's why I think it is very much relevant.
And all of that is a theoretical exercise at this point, because the LRTP lines that you're talking about in your testimony were approved in December 2024, and some of them may not go into service until the 2030s. Would you agree with that?
The Tranche 1 lines, the current schedule calls for them to come online, and the lines that are serving Wisconsin in Tranche 1 are slated to be in service, some of them by the middle of 2028, and the remainder by the middle of 2029.
Right, and then a lot of what you talk about in your testimony is the Tranche 2 lines. Would you agree with that?
I mentioned those. Those are as you said, less far along. I don't attach any precise megawatt quantities to them, but they are slated for completion in the 2030s. However, the Tranche 1 is going to significantly increase wind deployment in MISO, as well as the ability to import power into Zone 2 in Wisconsin. And those are, again, slated for completion this decade.
Right, but that's still theoretical because even those projects, for the most part, are still pending completed construction. Would you agree with that?
I mean, they're pending regulatory approval, but they're not theoretical. They've been approved by the MISO board, as have the Tranche 2.1 lines. And we've seen that the state the MVPs were all approved by the state commission. So I wouldn't say they're theoretical. They're very real.
Well, isn't one of the MVP projects Cardinal Hickory Creek?
It was, as was Badger Coulee.
Right, and those projects took upwards of a decade through regulatory approval to construction. Isn't that true?
Cardinal Hickory Creek had a complicated regulatory path. I think there's some, and I explained this at length in my SIR rebuttal testimony. I think Badger Coulee is much more analogous to the situation we are facing in this with the LRTP Tranche 1 lines. I was involved in both of those cases. Badger Coulee was completed on time. And I think that's much more analogous to what we're looking at here in terms of the route, the use of existing right-of-way. Cardinal Hickory Creek had a number of unique obstacles at both lawsuits at both the state and federal level that did not happen in the Badger Coulee case. And I think we're with Tranche 1, I think we're looking at something much more like Badger Coulee, which was placed in service on time.
You say you think that's what we're looking at because those processes are not complete as you sit here today, right?
That's correct. They're not complete. But again, with the route and the use of existing right-of-way for Tranche 1, I think it should be more similar to Badger Coulee than Cardinal Hickory Creek, which was a very unique set of circumstances.
Right. And again, that's just you predicting the future, right?
Yes, based on my experience as an expert witness in both of those cases.
Okay, thank you. I'm going to move on to the topic of reliability. Can you pay attention to that topic next?
Okay.
Did you read Jody Arndt's rebuttal testimony in this case?
I did.
And Your Honor, if you could bring up page 10 of Mr. Arndt's rebuttal testimony, I'd appreciate it.
Okay.
Are you generally familiar with Mr. Arndt's rebuttal testimony, Mr. Gagan?
Yes.
Beginning on page 10 and continuing through page 15, Mr. Arndt is discussing reliability concerns expressed by the North American Electric Reliability Corporation, otherwise known as NERC, Reliability First, and MISO. Do you agree with that?
Yes.
What is NERC to your understanding?
It's the North American Electric Reliability Corporation. It's the electric reliability organization that FERC has designated to set and enforce mandatory reliability standards.
And fair to say NERC's mission is to assure the effective and efficient reduction of risks to the reliability and security of the grid, right?
Sounds good, yeah.
And when we talk about the grid, there are a number of different acronyms you could use, but BPS, the bulk power system, would that be roughly analogous to the term grid?
Sure.
Do you think NERC is a credible source on the issue of grid reliability?
Yes.
What is reliability first to your understanding?
It's one of the NERC regional entities that plays a role in compiling information as well as NERC standards enforcements.
And so under delegated authority from NERC, Reliability First is responsible for the reliability and security of the electric grid, including for MISO. Do you agree with that?
Parts of MISO, that's correct, yes.
Do you consider MISO to be a credible source on issues of grid reliability?
Yes.
Do you consider Reliability First to be a credible source on issues of grid reliability?
Sorry, yes. Do you consider, I didn't get the end of the question.
Reliability First to be a credible source on issues of grid reliability?
And I said yes.
Yeah, thank you.
And without going through these 5 pages in detail, do you have any basis to dispute Mr. Arndt's description of NERC's and Reliability First's concerns about reliability in MISO?
Can I take a minute to read them? Just.
Sure.
Yeah, I mean, I think this is a fair representation of what NERC says. You know, I've been very active at NERC for 15 years, and what goes into these long-term reliability assessments is information that is provided by utilities and, in this case, the regional entity RFC, and that includes planned generator additions and retirements. And obviously, things that are planned don't always happen as they were planned. You know, retirements can be delayed, particularly with, you know, potential changes in EPA regulations and other, you know, factors in the market, just, you know, increasing demand. Markets are going to respond to that, and generator retirements will be delayed. New resources will enter the market when you have, you know, again, changes in EPA regulations that we're going to limit additions of new gas. And also just, again, supply and demand are going to drive market entry. So, you know, this report came out in December. It's based on information that was compiled over last year. There have been a lot of changes, you know, with the election in terms of the impact on EPA regulations, and then also just continued expectations for demand growth in the electricity sector. So, you know, I think, yes, taking the numbers at the face value, I think this is a good representation of, you know, what NERC said, but it was based on information provided a year ago that I think, you know, could be subject to change as the markets and the regulatory environment shift.
Aaron, do you mind scrolling to the next page, please? So, Mr. Goggin, this map shows NERC's assessments of the various regions within NERC's jurisdiction. And you see that MISO is the only jurisdictional area that's red. You see that?
Yes.
And that's NERC's opinion that MISO is at high risk of having inadequate resources to meet demand. Do you agree with that?
Yes, subject to everything I just said about this being based on information that was compiled last year, and you know, subject to, you know, changes in the regulatory environment, changes in the market that could totally change the projections that are included in the long-term reliability assessment.
And you could change, right? But you're not sure that anything has changed as you sit here today, right?
Well, certainly the market and the regulatory environment, I think, has changed, and, you know, anybody in the market would tell you that things are different than they were 3 months ago. You know, the way NERC does these, it compiles the list of planned resources, planned retirements, and things like that. You know, we will have to wait until, you know, December to see what the updated one is, but it certainly, I think anybody in the market would tell you that things have changed in the last several months.
It's not your contention that NERC's assessment is no longer applicable from December of 2024 to February of 2025. Is that your contention, that has changed to that dramatic an extent?
I wouldn't say it's not applicable, but there have been a number of fundamental changes since the information that was collected over the course of last year that went into this report was collected.
It's not your contention that the Trump administration's inauguration in January lowered the risk to MISO, is it?
I think the prospects for the greenhouse gas regulations are significantly dimmer than they were in October 2024, for example. And
the greenhouse gas rule is still the law as you sit here today. You agree with that?
Correct, but as I said, I think the outlook is clouded relative to where it was last October.
And as you sit here today, the Trump administration hasn't taken any administrative action to repeal the greenhouse gas rule. Is that true?
That's correct, not yet.
So you know, the cloudy day that you're forecasting is really just your personal opinion, not based on any fundamental administrative change, right?
It's informed by watching what's happening in the market and, how other utilities are dealing with this. I think in most utility planning, people are looking at cases with and without the greenhouse gas regulations, just to reflect that, there's significant chance that it could be the without outcome.
Is it your testimony that the vibes have changed since December 2024?
I didn't use that term.
Objection.
I think there's a fundamental
The
change.
form.
Oh,
Ultra.
Sustain.
Let's move on to energy efficiency or I'm sorry, Your Honor, if you could scroll to page 13, I think I have just one more question. Do you see there at the middle of the page, the quote from NERC? It says, natural gas-fired generators are a vital grid resource. See that?
Yes.
Do you have any basis to dispute that NERC made that statement and that NERC views natural gas generators as vital grid resources?
They made that statement, but the full context was in a paragraph where it talks, and some of it is included there, where it talks about natural gas is one source that can provide essential reliability services like flexibility. I would note there are other sources of that. Batteries are one. Renewable resources can provide flexibility. Hydropower, various types of thermal resources can all provide flexibility. So they're not unique in having that attribute. I would also note that if you look at the paragraph in the NERC's long-term reliability assessment that has this sentence, the second half of the paragraph then talks about the risks that gas generation has faced due to pipeline construction not keeping pace with the natural gas generation. And so my interpretation of the context of this paragraph is that NERC is concerned about the reliability of gas because of these pipeline constraints. Yes, that last sentence there, in particular, natural gas pipeline capacity additions over the past 7 years are trending downward, and some areas could experience insufficient pipeline capacity for electric generation during peak periods. I view this as more of a expression of concern about the reliability of gas than a positive statement.
The sentence at the beginning of the paragraph, it says natural gas-fired generators are a vital BPS resource, right?
That's what that one sentence says, but the rest of the context there, I believe, is more in line with what I've said.
Well, we'll disagree on that, but we'll move on to energy efficiency and demand response. Do you have that topic in mind?
Yes, it wasn't a big part of my testimony.
Sure. Is it your position that energy efficiency and demand response are potential alternatives to the Paris-Rice project?
Objection is irrelevant. We have other witnesses that testified to this.
It's about his position. If he wants to say it's not his position, that's fine.
So is this witness qualified?
We're just
statement.
Witness Goggin didn't testify about demand response or energy efficiency, and we have witness Sherwood who did.
He literally just said he testified about energy efficiency and demand response. It's in his testimony. It may be at a more limited degree than witness Sherwood, but it's in his testimony.
Okay, was it just stating witness Sherwood's conclusions, or is it something separate from the other testimony?
My understanding it is it's more than that. And if
where would I find it?
We can pull it up, but I mean, he literally just testified that it's in his testimony.
Right. I'm not. Yeah, I know it's in his testimony, but I'd like to see it.
Okay, we can pull it up and search.
I'll withdraw the objection if the witness wants to answer. I just want to note that we have a witness who testified specifically about energy efficiency and demand response.
Yeah, my recollection of what I said was that a portfolio of resources could replace the Paris-Rice unit. And I believe I cited to the other witnesses who then developed that portfolio and testified about it. And I think I mentioned that the portfolio could include demand side resources, but that was really, to my recollection, that's the extent of what I talked about.
I don't have much more than that, but I want to understand his position about it. And I think it's fair since he discussed it. I also think it's kind of fair to ask witness Goggin, who seems to be something of a summary witness, for two more very niche witnesses to ask him about the overall position that he took. But nothing is specific to.
It sounds like he's already answering the question, whether there was an objection or now it's been withdrawn. So, yeah, go ahead with your question.
Thank you. Is it your position that energy efficiency and demand response are potential alternatives to the Paris Rice Project?
It's part of the portfolio of other resources, including renewables, including batteries. That's what I testified.
Right. You know, you didn't testify that energy efficiency and demand response alone would be an alternative to the Paris Rice Project. Is that true?
I did not, because it was not within the scope of my testimony to develop an alternative portfolio.
Would you agree that the statewide focus on energy program has been effective?
That is outside of my testimony.
Yeah.
That's fine. Would you agree that the effectiveness of any energy efficiency program, including the focus on energy program, ultimately relies on the actions of consumers?
That was outside of the scope of my testimony.
You represented that you're an expert in this area, and you summarize other people's testimony. Do you have an understanding of energy efficiency and demand response programs and how they
Objection.
operate?
Unless council can show us in testimony where this was brought up, it's outside the scope.
You literally just said this would be part of a portfolio. So I think some reasonable follow-ups about his testimony that energy efficiency and demand response could be part of the portfolio of generating resources is fair. He has no understanding of energy efficiency and demand response. I'm not sure what the basis of his testimony would even be.
Now council is testifying.
I'm responding to your objection.
Do you have a response, Attorney Corday?
I maintain that focus on energy was not a subject of witness Goggin's testimony.
Okay, so if we were to ask him if he has any understanding of focus, he would say no.
Go ahead.
Do you understand what the focus on energy program is, Mr. Goggin?
I don't have a detailed understanding of it now.
But do you understand that it's the statewide energy efficiency program in Wisconsin?
I don't think I was aware of that.
Are you aware of how energy efficiency programs in general operate?
To some extent, yes.
Okay. Are you aware that for energy efficiency programs to be effective, consumers have to take action within those programs?
Yeah, I mean, it does rely on the consumer in conjunction with incentives and, you know, whatever utility measures are being discussed. That would make sense.
The utility cannot mandate participation in an energy efficiency program, correct?
That's correct.
The utility has to rely on consumers to take action outside their control, correct?
Sure.
And the same is true of the commission, right?
Sure.
The commission can't mandate that consumers participate in energy efficiency programs, correct?
No, it can create rate structures and other incentives.
You would agree that consumers also have to take action for demand response programs to work, right?
I'm sorry, can you say that question again?
Yeah. You would agree that consumers also have to take action for demand response programs to work, correct?
Again, yes, subject to the incentive structure, rate structure, and other, mechanisms that the utility and the commission have put in place.
Consumers need to opt into a demand response program in sufficient numbers for the demand response program to be effective, correct?
In general, yes.
Utility cannot mandate participation in a demand response program, right?
I don't believe that's typically done.
The commission cannot order consumers to participate in the demand response program either, right?
That's not typically done.
And in fact, it was probably outside the legal mandate of the commission. Would you agree?
I'm not.
Objection.
I'm not going to let him
legal,
answer.
legal conclusions.
No, stop.
I'll withdraw. You're not aware of any commission that has ordered consumers to participate in the demand response program, are you?
I am not.
Just like energy efficiency, the utility has to rely on consumers to take action outside the utility's control, right?
Again, the answer I've given is that the utility and the commission can set rate structures and other incentives that help drive consumer behavior.
But the choice to participate and the choice to modify their behavior is ultimately in the hands of the consumers, right?
Sure.
That's all the questions I have, Your Honor.
All right. Anyone else for cross? No, not hearing anything. How about redirect?
Yes, Your Honor. Mr. Goggin, in your opinion, going back to the line of questioning about NERC and MISO and reliability, in your opinion, do you think that these entities are implying that natural gas generation is the only way to address reliability concerns?
Absolutely not. If you read that paragraph that includes the sentence about natural gas and vital, it's clear that they're talking about essential reliability services, flexibility, and other things that, as I established in my testimony, batteries can provide, as well or even better in many cases than thermal generators like rice generators. I think what NERC is clearly talking about here is these essential reliability services are important. It never says the gas generators are the only ones that can provide that. I've testified at length that batteries can provide that service just as well. And again, that last sentence of that paragraph highlights the reliability risk that gas generation faces because of pipeline constraints.
Thank you, Mr. Goggin. No further questions, Your Honor.
Okay. Thank you. You're excused.
Thank you.
So, okay, what did I say? I think we're switching to Holloway. Was that the case?
That's my recollection, Your Honor.
Okay. So let's call witness Holloway. We'll have Town of Paris come up here.
Thank you, Your Honor. The Town of Paris calls John Holloway.
I'm sorry. Is this?
This is Jared Walker-Smith. Thank you.
I'm sorry. It cut out.
Jared Walker-Smith.
Okay. Yeah, your name's not on the screen, so I apologize for asking you again.
No worries. It extends beyond. We have two very long names up here.
Okay, I see witness Holloway there. All right. I'm going to ask you to raise your right hand. And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead.
Thank you. Please state and spell your name for the record.
John Holloway, JOHN HOLLOWAY.
On whose behalf are you testifying in this proceeding?
On behalf of the Town of Paris.
And what is your position with the Town of Paris?
I currently serve as town chairman for the past 6 years. Prior to that, I served as chairman of the Plan Commission for 28 years.
Did you submit in this proceeding direct testimony, surrebuttal testimony, surrebuttal testimony, and in relation to those testimonies, exhibits TOP Holloway 1 through 13?
Yes, I did.
Do you have any clarifications you would like to make to your submitted testimony or exhibits?
I offer no changes to my testimony. I would offer a clarification based on, in response to Judge Newmark's note, is that in my rebuttal testimony, I introduced Exhibit 11, in which it was a list of property values in the Town of Paris and in the neighboring Racine County, the Town of Yorkville. What I want to explain in my testimony was that this information was compiled by myself from data available on the Kenosha County and Racine County websites, and that so to provide additional context was that these are assessed values and estimated fair market values compiled by the local assessors, and they can be obtained from the interactive mapping and real estate interactive sites on both the Kenosha County and Racine County's websites, and that you can search for these properties and obtain by parcel that information. And so that's what I provided were information that I assembled from the county GIS websites.
Okay, thank you for that.
Thank you. Do you have any other clarifications you would like to make to your submitted testimony?
Yes, I felt that I could offer additional context with regards to page 10 of my rebuttal testimony, where I stated that the town of Paris adopted a land use plan. I'm sorry, adopted a land plan to guide the vision of the Kenosha County wide zoning. And what I was referring to there specifically was portions of the multi-jurisdictional comprehensive plan for Kenosha County 2035 as it pertains to specifically to the town of Paris, because it's a large document. And I was referring to pages 379 to 381 for clarification.
With those clarifications, if I asked you the same questions today, would your answers be the same?
Yes, they would be.
I would like to move Mr. Holloway's direct rebuttal and rebuttal testimony and exhibits TOP Holloway 1 through 13 into the record.
Yes, they're already in. Thanks.
Mr. Holloway is available for cross-examination.
Okay, any questions? No, I had you flagged. Did that someone change their mind? Okay. Or maybe it's just that you wanted him to participate. Okay, got it. All right, so no questions. So I was just curious, was that the land use plan from Kenosha, was that made an exhibit at any point? I thought I had seen.
No, the town did not offer it as an exhibit.
Okay. No. That's fine. I thought I'd seen it cross my screen at some point, but I guess I don't know where. Okay.
We'd be happy to do so if it would be useful to the commission for clarification, but
yeah, I don't know if it's not filed now. I think that's fine. We won't compel it to come in, and since parties haven't seen it yet, I'm not going to open that can of worms here. But I think I just thought I may have seen it before. I just didn't know where it was. Okay, but with that, no cross, so you're excused. Thanks very much.
Okay. Thank you very much.
Okay, take care. Okay, let's get back to clean. Who's our next witness?
Your Honor, Clean Wisconsin calls Stacy Sherwood. Good afternoon, Mrs. Sherwood. Could you please state your name for the record?
I need to swear in first.
Oh, sorry.
We'll need to see you there. Yeah. Oh, there we go. Okay. Yeah, when you get this many people on the screen, there we are. All right, let me pin you as well. Okay, great. So witness Sherwood, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, great. You're all set. Go ahead.
Thank you, Your Honor. Sorry about that.
No worries.
Ms. Sherwood, could you please state your name for the record?
My name is Stacy Sherwood.
And Ms. Sherwood, are you the same Stacy Sherwood that prepared and caused to be filed direct and rebuttal testimony and associated exhibits in this docket?
Yes, I am.
To the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes, they are.
And do you have any corrections to your testimony that you'd like to make today?
No, I do not.
Thank you, Ms. Sherwood. No further questions. The witness is available for cross.
I just wanted to verify there's 16 exhibits that you filed.
That sounds right, Your
That's
Honor.
what I have listed
can
here,
double
but you
check.
never know.
Yeah, they were
Yes.
just with direct.
Sounds like it was a yes. Okay, so any cross?
Your
Nobody?
Honor, this is Matt Frank from WLG.
Oh, yes. Okay, let me get you pinned up here. There we go. Yeah, I knew there was someone else had questions. So go ahead, Attorney Frank.
Yeah. Ms. Sherwood, in this proceeding.
And just introduce yourself to the witness.
I'm sorry. Ms. Sherwood, my name is Matt Frank. I'm an attorney representing Wisconsin Local Government Climate Coalition. Good afternoon.
Good afternoon.
Did you provide some testimony in this proceeding on energy efficiency and demand response?
Yes, I did.
Have you been listening to the questions that have been asked in this proceeding, suggesting that there's a limitation on EE and DR programs because they require consumer participation?
Yes, I have heard that.
And do you have familiarity based on your background about how a good program can work to ensure that there is customer participation in those programs?
Yes, I think there's several factors that could lend to a successful program implementation.
And could you just tell us how, your thoughts on how that's done?
Part of that can be the marketing of the programs, how they're being approached, whether it's through direct marketing sources or working with community-based organizations to encourage participation. It's in review of the incentive levels that can be offered to entice customers to take a part of the programs themselves. And it's also the program design, recognizing what measures need to be offered within the service territory and where the market needs to be transformed to.
And do you have an opinion as to whether there's additional capacity in Wisconsin for significant expansion of EE and DR programs?
I do believe that there is significant opportunity. As noted in my direct testimony on page 9, as well as page 10 of my testimony, I indicate the performance of energy efficiency in Wisconsin compared to other states. On page 9, it's figure 1, where I note that Wisconsin is significantly behind the top 10 states according to the ACEEE study, and actually ranks 26th nationally. And then on the page that's currently shown there on page 10, compared to surrounding states in Wisconsin, they are also significantly lower in terms of performance when it comes to energy efficiency.
All right, thank you. No further questions.
Okay, any other cross?
Your Honor, yeah, applicant would have cross on the topics that Mr. Frank raised, and similar cross to what we've done with other witnesses.
Okay, go ahead.
Thank you. Ms. Sherwood, I'm attorney Patrick Proctor Brown. I represent the applicant, Wisconsin Electric. We haven't met before today, right?
That is correct.
And as I just mentioned, I'd like to ask you some questions about energy efficiency and demand response. Do you have those topics in mind?
Yes.
Is it your position that energy efficiency and demand response are potential alternatives to the Paris-Rice project?
I believe that their potential portion to offset what is being requested in those cases. I don't believe that demand response and energy efficiency can completely replace the requested project.
Thank you. Would you agree that the statewide focus on energy program has been effective?
I think it depends on what your definition of effective is here.
What's your definition of effective?
I mean, I'm not the one asking the question here. So what is it that you're asking me to answer in terms of effectiveness?
So I think it's been widely testified in this case by, I think even Mr. Frank's witness, Allison Carlson, that the statewide energy efficiency program focus on energy has been effective at reaching its goals. Would you agree that the, generally speaking, focus on energy has reached its own goals in terms of energy efficiency?
Yes, it's effective in reaching its own goals. I think there's a question of whether those goals are set high enough to what needs to be achieved, and that the focus on energy is a statewide effort. And here we're looking at an individual service territory. And from the statewide effort, it's difficult to tell the effectiveness within one service territory.
And you recognize that the goals of focus on energy are set by the Wisconsin legislature and the commission itself, right?
I do recognize that. It's also established based on a minimum funding mechanism.
Actually, based on a maximum funding mechanism. Wouldn't you agree with that?
No, the funding is set as a floor.
I'm sorry.
The 1.2% is a floor of what can be offered into focus on energy.
So off the record, did you get that, Debbie?
The one, I don't know what you're saying. The 1.2 is a 4.
All right, the 1.2% is the floor.
The floor. I'm sorry. Okay, I was mishearing you. Go ahead.
And just, it may be more effective. There seems to be a slight echo or just a lower volume on your mic. So if we can just get closer, maybe, or just.
I've got AirPods in. I think this might be the best I can do. My computer audio is not good.
Okay, so
I'll talk louder.
You can't get any closer than that, I guess. All right. Let's keep. We'll just keep that in mind, and we'll play it by ear. Okay, let's get on the record.
You just testified that the focus on energy funding as a floor. What's the basis of that characterization of the funding level?
Is the fact that if you look on page 6 of my testimony, line 14, that WEPCO itself is required to spend 1.2% of their annual operating revenue derived from retail sales to fund the utility share of the statewide energy efficiency and renewable resource programs. That's line 14 through 16. That does not mean that the company cannot apply additional funding towards focus on energy or operate its own energy efficiency and demand response programs, which it currently does.
That funding level is established in statute in Wisconsin. Do you agree with that?
Yes, it is.
Are you aware of any mechanism for any Wisconsin utility to provide additional funding to focus on energy above the level required by the Wisconsin statutes?
Yes, it's my understanding that additional funding can be provided to focus on energy.
What's the basis of that understanding?
That the company, as part of their proposal, indicated that additional funding can be provided towards energy efficiency and demand response. And through the testimony provided by the company, indicates that it would be done so through focus on energy.
We disagree with the implication of that testimony, but we can go and look at it and it speaks for itself. Do you have anything beyond your reading of, I think, Brian Lambert's testimony that indicates that Wisconsin utilities can provide additional funding to focus on energy?
Not on hand.
Thank you. You would agree that the effectiveness of any energy efficiency program, including focus on energy, ultimately relies on the actions of consumers?
A consumer must take action to participate in the program, but I do believe that whoever is administering the program does have an ownership over getting that participation.
Right. The program manager could affect in some way the actions of consumers, but it is ultimately the consumers that must act. Would you agree with that?
In the case of energy efficiency, yes, that is the case.
So energy consumers do need to take action and participate in any energy efficiency program, right?
Not necessarily. If there's a behavioral demand response program that's typically given out, and that's an opt-out program, and savings can be generated that way.
The utility cannot mandate participation in an energy efficiency program, right?
No, it cannot.
The utility has to rely on consumers to take action outside the utility's control.
I would disagree that it's outside the utility's control or whoever's administering the program, because of the levers that can be used to generate participation in energy efficiency.
Right. So the utility could change the incentives, but the energy consumer is the one that has to act, right?
Including demand behavioral response programs, yes.
And even those behavioral response programs, as you mentioned, usually have an opt-out mechanism that the consumer can decide not to participate. True?
That is correct.
The commission can't mandate that consumers participate in energy efficiency programs, can they?
No, they cannot.
You would agree that consumers also have to take action for demand response programs to work, right?
No, I don't agree with that.
Why don't you agree with that?
For one, if we're talking about a formal demand response program, customers can opt in, but there are times when there are emergency events where customers cannot opt out of participating. That would require them to participate in a demand response program. In terms of an interruptible tariff, that pertains to the tariff that the customer is signing up for.
Okay, you listed two options there. One is an emergency reliability event. Would you agree that that is the first aspect that you're talking about?
Yes.
So essentially the entire system is having such a significant reliability challenge that they are forcing customers to reduce their electric load. Is that fair?
It doesn't always have to be the entire system. It can be a local event as well, but yeah.
Okay, whatever local grid is having the reliability event, you do not have enough electricity to meet load, and so you're forcibly reducing load from customers. Is that true?
That are participating in demand response program, yeah.
And that's not ideal from an electric grid reliability standpoint. Would you agree with that?
Of course not.
Thank you. And then the other option you talked about are interruptible tariffs. The customer has to opt into an interruptible tariff. Would you agree?
I believe it's based on the tariff structure. Some tariffs have an interruptible component of it. It is not separate. It is a requirement to participate under that tariff.
Customers are not required to, in any jurisdiction, to opt into an interruptible tariff, are they?
Can you repeat the question?
Let's read it.
Customers are not. Oops. Customers are not required in any jurisdiction to opt into an interruptible tariff, are they?
I don't think I can answer that question when you, as broadly as any jurisdiction. I think that we'd have to get into specifics.
Sure. Are you aware of a jurisdiction that requires customers to take service on an interruptible tariff?
Yes, I am.
What jurisdiction is that?
I'd have to, it is not within the state of Wisconsin. I could provide that though after.
Okay. And typically customers get to select what tariff they take service under. Would you agree with that?
Typically, yes. It really comes down to what the requirements are under the tariff.
The utility cannot typically mandate participation in a demand response program or an interruptible tariff. Would you agree with that?
I don't believe I agree on the interruptible portion, but I will agree on the demand response portion.
But as you sit here today, you can't point to a specific jurisdiction that does mandate customers to take service on an interruptible tariff, right?
Not off the top of my head, sir.
The commission generally cannot order consumers to participate in a demand response program. Would you agree with that?
I would agree with that.
So just like energy efficiency, the utility has to rely on consumers to take action outside the utility's control for a demand response program to be effective. Would you agree with that?
If the proper leverages are not provided as part of those program efforts, which have been proven nationwide to provide customers that do participate in the program, then yes, it ultimately does rely on the customer to participate. But there are plenty of opportunities for utilities or an implementer to make the program to be successful.
No matter what the tariff program design is, ultimately the consumer gets to decide if they want to participate in a demand response program. Would you agree?
Yeah.
That's all the questions I have, Your Honor.
Okay. Across from anyone else? Okay, redirect.
Thank you, Your Honor. Ms. Sherwood, does increasing load require action on the part of a customer? Sorry, in other words, utilities can't require a customer to take service or increase consumption or load, correct?
That is correct.
So both load and energy efficiency are subject to customer behavior, correct?
That is correct.
Thank you. And to clarify your answer on focus on energy, is there anything preventing WEPCO or any other utility from offering energy efficiency and demand response programs beyond those that are offered by Focus on Energy?
No, to my understanding, there is not.
Thank you. No further questions.
Okay, thank you very much. You're excused.
Thank you.
So any other witnesses from Clean? I think Holdling, yes. I'm gonna miss
Yes,
anyone.
thank you, Your Honor. Clean Wisconsin calls witness Chelsea Hoteling.
Okay, so I'm gonna watch for that mic to unmute.
Sorry, got my video but not my mic. Can you hear me?
Yes, there you are. Okay, just takes a second there. All right, excellent. Raise your right hand. Do you swear or affirm tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead.
Thank you, Your Honor. Ms. Hoteling, could you please state your name for the record?
My name is Chelsea Hoteling.
Ms. Hoteling, are you the same Chelsea Hoteling that prepared and caused to be filed direct and surrebuttal testimony and associated exhibits in this docket?
Yes, I am.
To the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes, they are.
Do you have any corrections to your testimony that you wish to offer at this time?
No, I do not.
Thank you, Ms. Hoteling. The witness is available for cross.
Okay, questions? We'll start with the applicant.
No questions, Your Honor.
Okay, anyone else? No? Okay. Had you down for questions, must have been my mistake there. Okay, well, that's all we need, and thanks, you're excused.
Thank you.
So we'll push on. Get this right. There we go. Push on to, let's see, I think commission staff and, no, sorry, Carlson. Okay, Wisconsin Local Government Climate Coalition, let's call your witness.
So, Your Honor, I apologize for this, but my colleague that's doing the cross, just step out for just a second. I wouldn't mind if we go to Mr. Minky next, if you could accommodate that, or we could just take a couple of minutes for her to return.
No, I think switching will be fine if that's okay with Government Climate Coalition.
It's okay. It's only going to be a few minutes of the other testimony, I assume.
Yeah, well,
I guess we don't know.
We can't assume. I've never assumed that. Okay, but we'll take we'll move on with our DNR witness, Minky.
Can we actually do all commission staff at once?
Sure, that'll work. So we just want to take them in order.
Okay.
Yes, you just want to take them in order?
That's fine.
Okay, let me get you set up here.
Actually, Tyler Tomaszewski has a.
It's up to you. Who do you want to call?
If you could go first, that would be great.
Okay,
So
go ahead.
commission staff would call it Tyler, and I'm gonna get the spelling of his name wrong, so I'm gonna look it up.
Tomaszewski.
Tomaszewski, thanks.
See here. Let's see. Oh, there he is. Not listening. Has to unmute.
Sorry about that.
There you go.
See me?
Let's get you pinned up here.
Hold a fast one on you, Tyler.
Okay, we got you. Okay. All set? I'll swear you in. Raise your right hand. Do you swear or affirm tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your last name for the record.
Tomaszewski. Would you like me to spell it as well?
No, we got the spelling. We're good.
Okay. I'm sorry if I said that wrong. Did you cause file or cause to be filed testimony, direct testimony, and errata in this docket?
I did.
And aside from any typographical errors noted by the judge and the ones in your errata, are the statements and representations in your testimony true and correct?
Yes, they are.
Any additions or modifications?
No.
Okay, open to cross.
Any questions? No? Okay, so just make sure we get that FEIS exhibit in, just the special exhibit with the link. That's all we're.
Yeah.
Okay.
Actually, if I may,
Yeah.
one more question.
Yeah.
Was that FEIS filed today?
Yes, it was. And the IRF reference number is 533072.
Oh, okay. Okay, so when you're saying the FEIS, you mean the exhibit?
Yes.
Okay, because the original So I just want to make sure we're clear for this. So I have here that the actual document was filed already, December 20th. So
It was, and we had failed to get the exhibit up in
That's
advance.
fine.
To Tyler to get it up today. Thanks, Tyler.
that's fine. I just want to make sure we're clear on what we're talking about. Okay, that's fine. So anything else?
Not
Okay.
from me.
Okay, thanks very much. Then you're excused.
Thank you.
Kristen Befield from DNR Commission staff calls Kristen Befield to the stand. Befield.
Okay, I see you there. And yep, you're all ready to go. So raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Did you file or cause to be filed the direct testimony and the exhibit X.cap AIS in this docket?
Yes.
And aside from any typographical errors that will correct, do you have any other modifications to your testimony?
No.
And are the statements otherwise accurate and correct?
Yes.
Open to cross.
Okay, just wanted to confirm. So in terms of typographical errors, you're just talking about the comments that I made?
Yeah.
Okay, and then I don't think we have the AIS filed yet. And so I just want to make sure I listed it on the offered evidence list, but if you could file what I have there included in the document as the exhibit. So it's just your standard looking special exhibit.
Will do. I thought.
Yeah, I don't think that's filed yet. So
Okay.
it just looks like that. Okay.
Okay, so exhibit with like the link to the AIS.
Oh, what did I do here? Oh, I
Looks like
actually
what-
did. Oh, because it's not file. Yeah, I guess I did that wrong, didn't I? Yeah, I just want to put the link in. That's what I meant to do, rather than the document itself.
We'll make sure that it makes sense.
Okay, great. Yeah, that's my mistake. But
Okay.
Okay, so any cross? No? All right, thanks. You're excused.
Thank you.
Commission staff calls Kayla Golden to the stand.
You there?
Yep, I'm here.
Okay.
Real quiet, Kayla.
I'll swear you in. Yep, there you go. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead.
Okay, did you file or cause to be filed the direct and rebuttal testimony as well as exhibit PSC Golden 1 in this docket?
Yes, I did.
And aside from the notes the judge made, are the statements and representations in your testimony and exhibit true and correct?
Yes, they are.
Any modifications or additions?
No.
Okay, open to cross.
Any questions? Okay, hearing none, you're excused. Thanks very much.
And I'm going to skip to Stacy Rowe for the sake of time. There's Stacy Rowe.
Okay, I see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Did you file or cause to be filed direct testimony in this docket?
Yes, I did.
And are the statements and representations in your testimony true and correct?
Yes, they are.
Any additions or modifications?
No, none at this time.
Okay, open to cross.
Any questions? Okay, seeing none, you're excused.
All right. Thank you.
Thanks.
Commission staff calls Stacy number 2, Stacy Schumacher. Stacy number 1 in my heart, of course.
Stacy Prime. It's Stacy Prime and Stacy 1.
Right.
There you are. Let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes.
Go ahead.
Did you file or cause to be filed rebuttal direct and an exhibit in this docket?
Rebuttal and an exhibit. Yes.
Thank you. Any additions or modifications to those?
No.
Okay, open to cross. I'm sorry, are those
Okay.
exhibits? I skipped a question. I'm sorry. Is the server rebuttal and the exhibit that you filed true and correct?
To the best of my knowledge, yes.
Okay, open to cross.
Okay. Any questions? Okay, there are none. Thanks very much. You're excused.
Thank you.
All right, and now we'll take David Minke, commission staff calls David Minke to the stand.
Here, raise your right hand. Do you swear or affirm to the truth, the whole truth, and nothing but the truth?
I do.
You're very low on your mic, so maybe adjusting there. Let's just try. Can you guys hear him? Let's give us another test word or two.
Can you hear me better?
You're very low.
Yeah, let's go off the record for this.
Better now?
Much
Oh,
better.
wow, that's great. Whatever you did, keep doing it. All right, so let's get back on, and you're sworn in, so go ahead.
Please state your name for the record.
My name is Dave Minke.
Did you file or cause to be filed direct testimony in this docket?
I did.
And are the statements and representations in your testimony true and correct?
They are.
Do you have any additions or modifications to add?
I do not.
Open to cross.
All right, who has questions for this witness?
Your Honor, Clean Wisconsin has a few questions.
All right. Go ahead.
Good afternoon. Good afternoon, Mr. Minke. My name is Brett Cordy. I'm a staff attorney with Clean Wisconsin. How are you today?
I'm good, thank you.
I have a couple questions about your direct testimony, starting on page 3. The decision to only submit a permit application for the preferred location is up to the, oh, I'm sorry, I'm quoting. On page 3 of your direct testimony, you say, the decision to only submit a permit application for the preferred location is up to the applicant's discretion. If the applicant were to apply for a separate air permit for an alternative site, it would take approximately 6 additional months for the DNR to issue a permit decision, end quote. So the applicant could have submitted an application for an alternative site at the same time as for the proposed site, correct?
Correct.
And other utilities have done just that, correct?
Correct.
For example, WPL submitted air permit applications 15-SDD-049 and 15-SDD-050 for its Riverside plant concurrently, correct?
Your Honor, I would just object to the line of questioning about permits from other utilities for other plants. I don't see how that could possibly be relevant in this docket.
And I would have,
overall, I think that's fine.
I would only object. It's not discussed in his testimony. The witness may answer to the best of his ability.
Yeah, he's a DNR employee, so working on permitting. So if we want to establish, foundation for that, competency to testify, we can. So that's fine. So
I'm okay without agreeing to the specific permits that I mentioned. He already answered the question about whether other utilities have concurrently applied, so I'm good. Thank you.
Okay.
So moving on. Also on page 3 of your direct testimony, you say that if constructed at the proposed site, the project would be a synthetic minor source for prevention of significant deterioration. That's acronym PSD, but not if located at alternative site 2. Is that true for both alternative sites 1 and 2?
I guess we haven't made a determination for the other alternate site, so I guess I can't speak to that.
Okay. So as to alternative site 2, can you explain why the project would not be a synthetic minor source for PSD?
Yeah. Yes, alternative site 2 is adjacent to an existing major source under PSD. So if the project was constructed at that site, it would be part of that same facility. So it would be looked at as a modification of an existing major source under PSD. So it would be subject to PSD review.
Thank you. So it's my understanding that the preferred site is located further away than the alternative site, but will be physically connected to the existing WEPCO Paris plant with a gas lateral pipeline and generation tie transmission line that would both be owned by WEPCO, that WEPCO will own property rights, including easements to contiguous property that includes both the preferred site and the existing Paris generation facility. And therefore, WEPCO has property interests in the connecting property that allows it to have both have access to the property and locate its equipment on the property connecting both parcels. So why are the new gas generating units located on the same gas lateral owned by WEPCO that serves existing generating units and located in order to use the same transmission system interconnection, not a single facility or installation under NR 405.0228?
When determining if two facilities are a single source, we look at whether they are adjacent or contiguous, and the two sites are approximately 1.6 miles away. And based on the permit application, We Energies does not own the property in between the sites. So we would consider them not to be adjacent or contiguous. And therefore, our preliminary analysis is that they would be considered separate facilities.
Thank you. So WEPCO says an important reason for selecting the preferred site is that it can use the same transmission system interconnection as existing generation at the Paris site. Is that relevant to DNR's single source determination?
I don't believe it is. I think in the past, EPA guidance considered functional interrelatedness of two facilities in making that determination, but more recent guidance focuses more on kind of the dictionary definition of adjacent, and that's the guidance that we follow when making these determinations.
Okay, thank you, Mr. Mickey. No further questions.
Okay, any other cross? No? Okay, redirect.
No, thank you, Your Honor.
All right. Thank you, witness Mickey. You're excused.
Thank you.
All right. So do we have any other staff witnesses? Looks like we're done with staff. So let's return to our party list here with witness Carlson. And my understanding is that's our last witness. So thanks for your patience there. Attorney Frank here. We'll just need witness Carlson to unmute, and that'll help me find her. Okay, there we go. Excellent. All right, I see you there. So we're swearing you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Thank you, Your Honor. Good afternoon, Ms. Carlson.
Good afternoon.
It's been a long day. You get to be the last witness today.
Yeah, the lucky one.
Did you, in this proceeding, did you prepare and file direct testimony and rebuttal testimony?
I did.
And did you, along with the testimony, did you also introduce 25 exhibits?
I did.
With respect to your direct testimony, is there any correction that you'd like to make to that testimony?
I do
And
have.
what would
Yes,
that
go
be?
I do have two small corrections. So the first one is page 26, on line 22. It should be exhibit 13, rather than 12. So that's the first one.
I believe
Or-
it's
or
line
20.
20.
Yeah. And then the second one is page 28, on line 16. That should, you see a 6% there, it should be 60%, 60. And that would be it.
Okay. Thank you. With those corrections made, if I asked you all the questions that I asked in the direct and rebuttal testimony, would your answers be the same today?
Yes, they would.
And to the best of your knowledge, is your testimony truthful and accurate?
Yes.
And Your Honor, I guess I don't need to move introduction at this point.
No, it's in. Thanks.
Okay, thank you. Thank you. I have no further questions and tender the witness for cross-examination.
Okay. So it looks like we had, excuse me, we had some refiling for the direct. And so just include those new changes as well on your refiled direct testimony.
I will include those, Your Honor, along with the direction that you had given previously.
Great. Thank you. All right. So I think we have cross-examination from, I don't know, from the applicant possibly.
Yes, thank you, Your Honor. Good afternoon, Ms. Carlson. I am Elizabeth Riccozzi on behalf of the applicant. It's nice to meet you. Good afternoon. I'm going to ask you a few questions about the energy priorities law and focus on energy from your direct testimony.
Okay.
Okay. So you testified on page 14 that the two top priorities under Wisconsin's energy priorities law is 1, energy conservation and efficiency, and 2, the development of renewable energy resources. Is that correct?
Yes.
And you would agree that the focal point of the law is meeting the public need for an adequate supply of energy, wouldn't you?
Yes.
And would you also agree that in exploring alternatives under the EPL or the energy priorities law, an important consideration is whether an alternative is feasible? Is that right?
Yes.
Is it your position that the EPL requires the commission to reject a proposed project in favor of a higher ranked alternative, even if that alternative is not feasible to implement on the timeline necessary to meet identified capacity gaps?
I'm sorry, could you just repeat the question for me?
Let's read it back.
Thank you.
We'll read it back.
Question, is it your position that the EPNL requires the commission to reject a proposed project in favor of a higher ranked alternative, even if that alternative is not feasible to implement on the timeline necessary to meet identified capacity gaps?
I believe I do. I'm not a legal expert here. I do think the energy priorities law also states that energy efficiency and conservation must be sufficiently considered as well. And to that I speak in my testimony that I don't think it was sufficiently considered in the application.
But it wouldn't be your position that consideration requires a rejection of a given project, correct?
Right.
And just to also confirm, you did testify on page 14 of your direct testimony that natural gas is a stated priority under the EPL, right?
It is. It is 5th, it looks like.
Yeah. And your direct testimony on page 27 acknowledges that Wisconsin Electric's application did in fact address EE and demand response, right?
I'm sorry, did address?
Energy efficiency and demand response.
I did, and like I said, I didn't believe it addressed it sufficiently for energy priorities law.
With respect to focus on energy, your direct testimony on page 26 also acknowledges that Wisconsin Electric is not statutorily obligated to offer more energy efficiency than focus on energy. Isn't that correct?
Right.
And you testified at page 19 of your direct testimony that focus on energy spending is capped at 1.2% of operating revenues. Isn't that right?
Yes, that is how it appears in statute.
So you would agree that the Wisconsin legislature, not Wisconsin Electric, sets the appropriate amount of funding, right?
I'll object to that question, ask for a conclusion about the law and the legislative action.
I believe Ms. Carlson just stated that it was in the statute.
Well, she's not testifying as a legal expert here.
But her testimony states that exact on page, sorry, I believe it's at page 19 of her direct testimony. She refers to the statutory cap.
Where, okay, so is that line 14 and 15?
No, page 19. Oh yeah, I'm sorry, lines. Yes, correct.
Yeah, so there is no clean energy standard in Wisconsin. Focus energy is capped at 1.2% of operating revenues. So that's, this testimony speaks for itself. I'm going to let that statement stand, if that answers your question.
Yeah, thank you. And are you aware that the commission itself, not Wisconsin Electric, sets the focus on energy savings goals?
Yes, I am.
So it's fair to say that Wisconsin Electric does not set its contribution limit or focus on energy goals. Isn't that right?
That's right.
And the goal of focus on energy isn't to achieve a specific amount of energy savings for a specific utility during peak periods, is it?
I'm sorry, could you repeat that again just to make sure I understood what you said?
Let's read it back.
Question: and the goal of focus on energy isn't to achieve a specific amount of energy services for a facility utility during peak periods, is it?
Excuse me, I believe it was energy savings.
Yes, I agree with that.
And the effectiveness of any energy efficiency program, including the focus on energy program, ultimately relies on the actions of customers, right?
I think that's an overstatement. The customer certainly has a role to play. They are the end use customer that would be taking advantage of a program. But as Witness Sherwood said earlier, there is a lot more that can be done on behalf of the program administrator or the utility to ensure that there's effective outreach and awareness, effective program design and incentive design. So there's a lot to it that kind of influences that customer's ultimate decision.
Sure, but it wouldn't be your position that the utility could mandate a customer to participate in an energy efficiency program, is it?
No, the utility couldn't make a customer participate.
So the utility has to rely on customers to take action outside of their control, isn't that correct?
Yes, but there also is a lot that is under their control to ensure that a energy efficiency or demand response program is successful.
Sure, but they cannot force a customer to participate.
No, Witness Sherwood also did talk about opt-out programs and opt-in. Opt-out would be something where the customer is automatically participating in the program and they can opt out later. Though from my experience and knowledge, typically, those types of programs have pretty low dropout rates.
But they still have a choice, to opt in or to opt out.
Yes.
Thank you. And the commission can't mandate that customers participate in energy efficiency programs, correct?
No, but like the utility, they also certainly have a role in ensuring that effective program designs and outreach efforts are pursued.
But again, they cannot, force a customer to participate.
No.
Again, and consumers need to opt in to a demand response program in sufficient numbers for that program to be effective. Isn't that right?
Yes.
The utility cannot mandate participation in a demand response program either, can it?
No.
And the commission cannot order a consumer to participate in a demand response program, could they?
No, but again, you go back to the tenants just to make a program effective and to increase and encourage participation. So there is a lot that is within the control of the utility or the commission to make sure an effective program is out there.
Sure, but if no one participated, it certainly wouldn't be effective, correct?
Right.
So just like energy efficiency, demand response requires the utility to rely on consumers to take action outside of the utility's control, right?
Yes.
Thank you. No further questions.
Any other cross? No, not seeing anyone. Okay, redirect.
Thank you, Your Honor. Ms. Carlson, in answer to one of the questions, you said that you believe that the application was insufficient in analyzing energy efficiency and demand response. Could you just expand on that a little bit here?
Sure. Yeah, from my read of the application and the exhibits, it was pursued, and I believe WEC also stated this at a high level. A high level analysis was completed. To me, that in and of itself indicates that an in-depth analysis was not performed. So that's one piece of it. Other witnesses mentioned it at a high level, energy efficiency, demand response, but not discussing it in depth. So that was part of my assessment there.
You were also asked some questions about the Focus on Energy program. You have knowledge and experience with that program, do you not?
I do.
And could you talk about whether you believe the historical savings that in terms of energy use that Focus on Energy has achieved are limiting, and there is no way to exceed those energy savings in the future?
Mm-hmm. Yeah, I think the assessment that's been performed, like you said, looks back historically at historical performance, and that can certainly be good information to have, but the dynamics of the market and technologies are changing. So you do also need to really look ahead. And that's where in my direct testimony, I cited numerous studies from market researchers, from other utilities, from federal agencies that really highlight the big potential there is for energy efficiency and demand response. And, while market factors will look a little different in Wisconsin, I think, that's something you really can't ignore. And pursuing additional energy efficiency and demand response is really something that should be done.
All right, thank you.
All right, just had one clarifying question for the witness. Witness Carlson, you're not an attorney, are you?
I am not.
Okay, thanks. Okay, I think that's it then. Anything else for this witness? All right, you're excused. Thanks very much.
Judge, I am embarrassed to say that I forgot to get in the staff standard, the standard comment and data request response exhibits. And I need to recall Kayla Golden.
For what purpose? I don't, to just to offer it. It's already on the evidence list. So
oh, okay.
I think we're all expecting it. I don't think that's going to be a surprise to anyone.
Thank goodness. Okay.
Yeah, I mean, sometimes we may bring that up, but I think a lot of times we don't. So you're okay. So we will. I think parties should expect to see after the public comment period closes, you'll see a special exhibit labeled EX PSC comment, and that'll have all the comments that I've accepted and received for the record. That's prepared and filed by staff with my involvement. So yeah, that shouldn't be a surprise to anybody. But I appreciate you raising that because it's always good to give everyone a heads up.
Thank you so much. She'll be more forgiving.
Okay, so anything else we need to address before we adjourn? Did want to remind people. No, okay. I did want to remind people that the refilings are going to be due in 3 business days, as well as the witness affidavits for people who were excused from appearing. And yeah, any new, I don't think there are any new exhibits. Well, no, I don't think there are new ones. So yeah, three business days for refiling and for the exhibits that need correction. And the Sursa rebuttal that hasn't been filed yet. That's all due together.
It maybe doesn't need clarification, Your Honor, but we have a delayed exhibit for the application and the tariff docket, which I think will just be a notification exhibit.
Yes.
That's not going to come within 3 days, I don't think,
No.
but we'll get it on file.
Right. Yes, you're correct. So the let me just refresh my memory. The application is which that you just referred to?
So not the application in this docket, but we marked an exhibit for Mr. Stasek as placeholder for a notification of the application for the very large customer tariff and the bespoke resources tariff. That'll come at some point in March.
Yes. Okay. That's right. Yes. Okay. I see what you meant by application now. All right. Great. So anything else?
Nothing from applicant, Your Honor.
Okay. Anybody else?
Your Honor, when do we have to file our revised testimony that we held off?
Okay, we can go off the record for this then. Yeah, I'm not seeing you pop up. Is this Attorney Frank or?
Yes.
Okay, there we go. Let me pop you up here, pin you. Yeah, so maybe I was just speaking too familiarly with everyone here. So the refiles are due in 3 working days. So I think we're still on track. If you want to look at your pre-hearing conference memo, that date should be stated there, but I would set it at well, let's just go off the, we are off the record, right?
Mm-hmm.
In lieu of getting it wrong, let me just tell you the right one. Oh, that's interesting. Okay, IRF isn't working right right now. Okay, well, let's see. If we just count 3 working days, it should be Tuesday, right? 1, 2, 3. Tuesday by 1:30, I think, is the date. The 18th should be the date in the pre-hearing conference memo. I would double check that. I don't mean to change the date in case I'm getting it wrong, but I can't access the document right now. So so yeah, so that would be all the testimony exhibits that we've indicated need correction should be filed by that deadline.
Thank you.
Okay, great. Anything else? Oh, we have a hand
Yes,
up?
Your Honor.
Yes.
One clarifying questions, and apologies, I should probably know this, but if we offer corrections on the stand, do those need to go in errata as well?
No,
Or,
no,
I'm sorry, refiling?
Refiling, yes.
Okay.
But we've already technically, you know, we've the RATA deadline's passed. Whatever corrections you made on the record, we have a recording of that. So a RATA wouldn't be necessary. We're all on board with those changes. But yeah, if you could put them in your refiling, that would be necessary for the commissioners to see the correct document. Okay. Willing to entertain any other procedural questions while you have a chance? Okay, I'm not hearing any. All right, thanks very much, everyone. We're ending close to 5 p.m., so I appreciate that. And looks like we're still in good spirits, so no harm done there. Thank you very much for attending, and we're adjourned. Take care.
Thank you, Your Honor. Thank you, Debbie, for patience.